2, 1. We are live.
Good evening. Welcome to the January 23rd, 2025 Rental Housing Committee regular meeting. The meeting is called to order at 7 p.m. All committee members are present with the exception of Member Rosas, who is absent. We can do the consent calendar. All right. These items will be approved by one motion unless any member of the committee wishes to remove an item for discussion. The purpose of the consent calendar is for the committee to efficiently and quickly consider routine or administrative business items with one motion. Public comment will occur after the discussion. We invite you to submit a speaker card now if you would like to speak on this item during public comment. Would any member of the committee like to pull an item? All right. I now invite public comments. In-person public comments will be called to speak first. Any member of the public wishing to provide a virtual comment on this item, please click the raised hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. Andrea, do we have any hands? I can't see them because I'm not a panelist.
There are no hands raised. And you can promote yourself, I believe.
Thank you.
Yeah, you're welcome.
All right. Seeing no comment, I'll bring the item back for committee action. A motion to approve the consent calendar should include reading the title of the agenda item 3.1. Vice Chair?
Thank you, Chair. I move to approve the Rental Housing Committee meeting minutes for the December 12, 2024 RHC meeting.
I have seconded.
All right. Motion made and seconded. Can we kick off the vote, please? All right. Motion passes unanimously. For the record, a motion was made by Vice Chair Ma and seconded by Committee Member Cox. And we'll now open the meeting for oral communication from the public. This portion of the meeting is reserved for persons wishing to address the committee on any matter not on the agenda. Speakers are allowed to speak on any topic for up to 3 minutes during this section. State law prohibits the committee from acting on non-agenda items. Would any member of the public like to provide comment on a non-agenda item? Any member of the public wishing to provide a virtual comment on this item, please click the raised hand button in Zoom or press *9 on your phone. All right. Seeing none, we can now move on to the appeals. The Rental Housing Committee, in hearing the appeal, is acting in a quasi-judicial fashion and will conduct the hearing in accordance with those standards. Staff will detail the appeal hearing process in their presentation. Before we get started, RHC members are required to disclose any communications that they have had with any of the parties to the petition or the party's representatives and the substance of those communications since the date that the petition was filed. The decision of the RHC is to be based on the record presented to the hearing officer. Information disclosed to...
We have translations this evening, so if we can go a little bit slower. Thank you.
Are you going to be translating the introduction?
They're translating over the headset.
Okay. Oh, got it. Okay. The decision of the RHC is to be based on the record presented to the hearing officer. Information disclosed to any RHC member that is not part of the record is not to be considered in the hearing. Do any RHC members have ex parte communications that need to be disclosed? All right. Seeing none, we will now proceed with public comment for both agenda items 5.1 and 5.2. So anyone who wants to comment on either of the hearing?
Just as a reminder, this is public comment for people who are not parties.
People who are not parties to either petition or appeal who would like to comment on the appeals. So any member of the public wishing to provide a virtual comment on this item, please click the raised hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. Seeing no comments, we will now move to agenda item 5.1. appeal hearing officer decision for petitions number C23240057 and C23240058. We will now proceed with the hearing.
Yes. Good evening. So the purpose for tonight is to consider the tentative appeal decision and either accept that tentative appeal decision or modify it with instructions to staff citing to the appropriate evidence in the record. So just as a summary of the process, we're going to go over the RHC process on the appeal hearing, the schedule for the appeal hearing, and then the actual petition. And for tonight, you have 2 appeal hearings. So we'll do the introduction for both of them, and then we'll go into the first appeal hearing. Next slide. So the RHC has a couple options when considering appeals. When they hear and decide the appeal, they can go with a closed record, deciding based only on the facts that were in the decision written by the hearing officer, or you could do a formal hearing process, open the record, and consider new evidence. We don't recommend opening the record. There was plenty of evidence submitted at the hearing initially, and opening the record and having a full evidentiary hearing would actually be quite a significant undertaking. So if there are issues that come up in the closed hearing procedure that weren't considered at the hearing that the RHC wants to be considered, one option is to remand the matter back to the hearing officer to conduct a hearing. So in considering the appeal, the RHC has to exercise independent judgment on questions of law, such as statutory interpretations. This, just to be confusing, is also called de novo review, but it's not de novo review of the evidentiary basis. For questions of fact, the RHC has to determine whether or not each appealed element of the hearing officer's decision is supported by substantial evidence. You're not re-weighing the evidence or relitigating issues. It's based on the record submitted to the hearing officer, and it doesn't mean that the members of the RHC would have come to the same conclusion as the hearing officer. Next slide. As I already said, we don't favor de novo review. That's a new formal hearing. It requires a significant undertaking, and there was substantial evidentiary evidence presented at the hearing with the hearing officer, and there's no indication that there's a need for additional evidence. Next slide. So in considering the appeal, the petition defines the scope of the hearing officer's decisions. So the hearing officer makes decisions based on what the petition raises. The appeal hearing is limited to the matters that are raised on appeal. So it's even more narrowed down than the hearing officer decision. Next slide. So this is just a graphic showing you how the petition process works. The petition is submitted, the hearing is held, there's a decision, that decision is appealed. If the appeal affirms the hearing officer's decision or modifies it, but makes a decision and adopts an appeal decision, that's considered a final decision, and the RHC process is concluded. Either party does have an option of a court challenge. If you remand the decision back to the hearing officer, then it will go back to the hearing officer, and then it could come back for a subsequent appeal depending on what the hearing officer decision on remand is and whether either party appeals it. Next slide. So your regulations have a process for appeal hearings. The first step in the process is public comment, applicable to all appeals being heard that evening, which we've already done. Staff presentation, then the appellant will have 10 minutes to present their arguments. The respondent will then have 10 minutes, and then the appellant will have 5 minutes to rebut, and respondent will have 5 minutes of rebuttal. After that, we'll take questions from the RHC for staff. The RHC can then question both the appellant and the respondent, and then we'll move into deliberation. Next slide. Okay, so getting into the appeal on these two petitions. Next slide. So once again, the purpose is to consider the tentative appeal a decision and either accept it or modify it with appropriate instructions citing to the record. Next slide. Oops, we seem to have the same slides. Let's keep going. Okay. Yes. Okay. So the appeal before you is with regard to a petition for downward adjustment that was based on 3 issues: habitability conditions, a reduction in housing services, and unlawful rent. Next slide. Petition for downward adjustment sought a downward adjustment based on habitability issues. The petitioner experienced ongoing harassment from the petitioner's neighbor, who was also a tenant of the respondent. The harassment was severe and significant and resulted in petitioner being diagnosed with and treated for PTSD, and ultimately petitioner moved out of the unit. Petitioner also raised an issue of a decrease in housing services, and the respondent removed petitioner's hose used to water outdoor plants. Next slide. The petition also sought a downward adjustment based on unlawful rent. Claiming that the respondent failed to roll back petitioner's rent pursuant to the requirements of the CSFRA, and that respondent raised petitioner's rent in violation of the CSFRA. Next slide. So this is just a graphic of the appeal timeline. This is all pretty straightforward. Just as a reminder, I thought I updated this slide, but apparently I didn't. This appeal apparently came before you on initially came before you on December 12th. The appellant respondent was sick and requested a continuance, which you granted, which is why we are here tonight. Next slide. So the hearing officer's decision found that the petitioner had met her burden of proof with regard to the respondent failing to protect petitioner's quiet enjoyment of her unit, which decreased her housing services, and failed to maintain a habitable unit by failing to respond adequately to the harassment. And the hearing officer ordered a rent refund of $8,000. Next slide. The hearing officer also found that the petitioner had met her burden of proof with regard to the unlawful rent. The respondent had failed to roll back petitioner's rent to the base rent date pursuant to the requirements of the CSFRA, and had retained unlawful rent starting January 2017 through September 2023. The hearing officer ordered a rent refund for the unlawful rent of $8,530. So the hearing officer ordered a total rent refund for both issues of $16,530. Next slide. The hearing officer found that petitioner had not met her burden of proof with regard to the decrease in housing services related to the hose and the removal of the hose, so there was no rent reduction ordered for that. Next slide. The hearing officer also made some additional findings based on issues that were raised at the hearing, including that the hearing officer is not authorized to decide whether the CSFRA rent rollback provision is constitutional, that California Civil Code Section 340, which has a 1-year statute of limitations in situations where treble damages are required, does not apply to this hearing. The hearing officer found that the hearing officer was not allowed to offset the award by funds that the respondent claimed were owed to the respondent by petitioner, that the hearing officer did not have jurisdiction to address the validity of petitioner's 30-day notice to vacate the unit. The hearing officer also did find that the unit was not properly registered in 2021 and 2022. Next slide. The appeal raises a total of 14 issues, all of which are addressed in the tentative appeal decision. The first issue that is raised is that the hearing officer erred in stating that petitioner failed to pay rent in September and October of 2023. Second issue was that the hearing officer erred in stating the petitioner filed her petition 133 days after the petitioner vacated her unit. The hearing officer's decision regarding the failure to roll back rents should be reversed because the rent rollback is unconstitutional. The hearing officer erred in stating that some of respondents' increases of rent occurred more frequently than every 12 months. The hearing officer erred in failing to properly address respondents' evidence on the issue of whether the unit was properly registered in 2021 or 2022. The respondent also argues that the petitioner failed to take the necessary actions to stop the harassment. The hearing officer decision regarding the rent refund should be reversed because the lack of safety does not fall within the scope of the CSFRA. The hearing officer's decision regarding the rent refund due to the lack of safety should be reversed because harassment is not a reduction in housing services, a failure to maintain or repair a unit, or a failure to maintain a habitable unit. The hearing officer's decision to award damages is supported by the evidence. The hearing officer erred in failing to give petitioners inconsistent testimony regarding the hose sufficient weight. The hearing officer decision should be reversed as to any claims going back more than 1 year. The hearing officer's decision should be revised to allow respondent to offset debts a petitioner allegedly owes respondent against the rent refund respondent is ordered to pay. The hearing officer erred in stating that petitioner's 30-day notice to vacate her unit is valid, and the hearing officer decision should be reversed because petitioner's claims are not supported by a preponderance of the evidence. So, as I indicated, the tentative appeal decision does address each issue that is raised in the appeal. The first issue about the error in the failure to pay rent, the hearing officer did make an error. The month should have been October, November, but the error does not impact the decision. The tenant did move out of the unit on September 30th, and the rent refund decisions are not impacted by that error. There's also a claim that the hearing officer made an error in stating that the petitioner filed the petition 133 days after the petitioner vacated the unit. That was an error as well. This is relevant because tenants must file their petition within 180 days of vacating. The petitioner filed the petition within 164 days of vacating her unit, so within the 180 days. So once again, although there was an error, it does not impact the decision. Next slide. The hearing officer's decision regarding the failure to roll back rents should not be reversed. The appellant claims that this provision of the CSFRA is unconstitutional. The hearing officer is not authorized to make a determination of whether the CSFRA is constitutional or not, and so the hearing officer acted appropriately and did not consider that issue. Next slide. The hearing officer didn't err in stating that some of respondents' increases of petitioners' rent occurred more frequently than every 12 months. There were numerous examples in the evidence where the rent that the petitioner paid increased in less than a 12-month period. The petitioner presented a rent record, and the respondent did not object to that or present any rebutting evidence, and in fact indicated that it looked correct. Next slide. The hearing officer did not err in failing to properly address respondents' evidence on the issue of whether the unit was properly registered in 2021. So the respondent provided evidence of clerical errors on the part of the City of Mountain View staff for the unit's 2023 registration, but no such evidence was provided with regard to 2021 or 2022. It's not clear if what the appellant is stating is there should be a supposition made that the same clerical errors were made, but without any evidence to that effect. The hearing officer could not make a decision on that and determined that it was not properly registered. Next slide. Petitioner's actions regarding the harassment do not negate a landlord's duty to provide and maintain a habitable unit, to maintain the requisite housing services, and to provide petitioner with quiet enjoyment. So respondent argues petitioner should have done more to stop the harassment, including arguing that the petitioner should have moved out, which ultimately the petitioner did, should have gotten a restraining order, which ultimately the petitioner did. But those self-help actions don't negate respondent's duty to provide petitioner with a habitable unit, to maintain the housing services, and to provide the petitioner with quiet enjoyment of her unit. The appellant also argues that the lack of safety and security does not fall within the scope of the CSFRA. The argument is that the harassment should be classified as a dispute amongst neighbors, and that these disputes are not within the purview of the CSFRA. The petitioner provided a significant amount of information about the sustained nature of the harassment, the security threat, and the negative impact on petitioner's health. It goes significantly beyond a dispute between neighbors, and respondents' actions represented a failure to maintain a habitable unit and a decrease in housing services. Next slide. The ongoing harassment and threats directed toward petitioner constitute a breach of petitioner's right of quiet enjoyment of her unit, a decrease in housing services, and a lack of safety arising from failure to maintain a habitable unit. So inherent in every lease in California is the right of a tenant to quiet enjoyment of their leased property. Landlords have a duty to protect against interference with this quiet enjoyment, and that includes interference that stems from the actions of other tenants, and there is case law cited in the tentative decision to that effect. And once again, the petitioner provided a significant amount of evidence that the harassment was pervasive, long-term, ongoing, and that it had negative implications for the petitioner over that time period. Respondent claims that they were powerless to address the harassment, but respondents failed to do anything about the harassment and only sent notice to the tenant that was the perpetrator of the harassment once they received the petitioner's restraining order. Next slide. The ongoing harassment and threats directed toward petitioner constitute a breach of petitioner's right of quiet enjoyment, represent a decrease in housing services and lack of safety. So decrease in housing services, the CSFRA defines housing services to include any benefit, privilege, or facility connected with use or occupancy of any rental unit. One of those benefits and privileges is the covenant of quiet enjoyment. The hearing officer, in reviewing all of the circumstances, determined that the housing services that the petitioner was receiving, taking into account the harassment, were valued at $705 a month, which was a $250 a month reduction from the rent, the legal, lawful rent that the tenant was paying. Next slide. So the ongoing harassment also constitutes a failure to maintain a habitable unit. The appellant respondent argues the harassment doesn't fall into the definition of an uninhabitable unit provided by the California Civil Code 1941.4. However, the CSFRA has broader requirements for landlords to maintain habitable units, and landlords do have an obligation to address security concerns. Next slide. The hearing officer's decision regarding the rent refund is supported by a preponderance of the evidence. The hearing officer awarded a rent refund for failure to roll back the rent. It was supported by evidence of the rent paid by the petitioner. Respondent did not refute or provide any rebuttal evidence regarding the rent actually paid and collected by the petitioner. Respondent does not dispute the fact that the rent was illegal. Respondent contends that the requirement to roll back the rent is illegal. Next slide. In terms of the harassment, once again, there was ample support in the evidence and preponderance of the evidence of the hearing officer's decision to award a rent refund based on the harassment. There's actually quite extensive record on that. Next slide. So the hearing officer didn't err in failing to give petitioners inconsistent testimony regarding the hose sufficient weight. The argument in the appeal is essentially that there was some potential inconsistencies in the petitioner's testimony about whether the hose was new or the hose was given to her by someone. And the appellant respondent claims that based on that, the hearing officer should have discounted all of the petitioner's testimony because of that inconsistency. There's no evidence in the record that any of her other testimony is inconsistent or untruthful. The hearing officer didn't address the evidence with regarding the hose because the hearing officer found that the removal of the hose was not a reduction of housing services. Next slide. The appellant respondent also argues that California Civil Procedure Section 340 should apply to this hearing. Section 340 requires that actions where there is mandatory treble damages must be brought within 1 year. There's a statute of limitations. However, Section 340 applies to civil actions in courts. This is an administrative procedure, and treble damages are not authorized for your hearings. Treble damages are only authorized under the CSFRA under very narrow circumstances, and they can only be awarded by the Superior Court. Next slide. California Civil Procedure Section 43170 also does not apply to this hearing. Once again, that section applies to civil actions in court, not to administrative hearings. It is a section that allows offsetting of damages, but this is not a civil action, and the requests to offset some of the amounts fall outside the jurisdiction of the Rental Housing Committee. Next slide. The hearing officer did not state the petitioner's 30-day notice to vacate is valid. The respondent argues the hearing officer erred in declaring that it was valid, but the hearing officer actually stated that she would not address the validity of the letter, but that generally a legal notice by an authorized legal representative is generally valid. But she did not make any claim about the specific notice. Next slide. Once again, the appellant raises that petitioner's claims are not supported by the preponderance of evidence. They are. We've gone through some of that already, and the tentative appeal decision goes through that very extensively. Next slide. So the tentative appeal decision was provided to both the parties before the original December appeal date. The appellant filed a response. That response included a variety of issues, including that the hearing officer's factual errors demonstrate the entire decision is in error and biased, that the hearing officer, actually I'll go through each of these one by one. As noted in your staff report, there's no evidence in the record of any bias on the part of the hearing officer, both in the decision and in reviewing the recording of the hearing. It is a very well-conducted hearing and followed all the due process requirements. The response also argues again that the hearing officer should conclude that the CSFRA is unconstitutional and refuse to enforce it. And once again, that is outside the jurisdiction of your hearing officer. The respondent argues that they did not intend to increase petitioner's rent more than every 12 months, but the records do indicate that there were increases and rents paid, and respondent did accept those rent amounts. The response also argues again that disputes between tenants or issues of quiet enjoyment cannot be resolved through the CSFRA hearing process. The hearing officer found it was a reduction in housing services and implicated the habitability of the unit, both of which are allowed to be addressed in the hearing. Harassment is not a reduction in housing services or a failure to maintain a habitable unit. We've addressed that in the tentative appeal decision pretty extensively. And once again, it did affect the habitability of the unit. The harassment was severe and extensive. The appellant also raises an issue that the hearing officer may not rely on city records or conduct their own investigation. This relates to the hearing officer referencing the registration records. That is addressed in the appeal decision as well. It raises the issue of the petitioner's false testimony regarding the value of the hose. That is also addressed in the tentative appeal decision. And then once again, as we just discussed, it raises the application of California Civil Procedure Codes 340 and 431.70, neither of which are applicable to these proceedings. Next slide. So that ends the staff presentation. And once again, we are recommending that you either consider the tentative appeal decision and accept it, or if you elect to modify it, that you give us instructions citing to the appropriate evidence in the record. Thank you.
Thank you. All right. You ready? It is now time for the appellant landlord. Please come to the lectern if you were speaking in person, which I see you are. The speech timer will be displayed on the screen. You will have 10 minutes.
Okay, my name is Leonard Siegel. My wife and I own the property. I would point out Mr. Garcia is no...
Can you just aim at the mic? Like if you want to bring it a little closer, yeah. It bends, it's pretty
Is it
flexible.
okay?
A little closer?
Okay. Ms. Garcia is no longer a tenant in the property. She vacated the property. Ms. Garcia has a restraining order, as you know, against the person she said was performing these acts of harassment. From my understanding, that's not an issue any longer, so, because the TRO is in effect, or at this point, it's not a TRO, it's a restraining order. Ms. Garcia said at the December 12th hearing that, and I quote, she did not care about the money and that she was not doing this for the money. Since these are unambiguous statements, the question is, why are we even here? She's not being harassed anymore. The restraining order is in effect, and she doesn't care about the money. There are several factual misstatements, arguments, and conclusions in the tentative decision that have been addressed in our response. There are also several legal arguments affecting the hearing officer's decision, as well as the committee's tentative decision. One additional issue. The hearing officer's decision awards Ms. Garcia certain sums of money for overpayment of rents. However, that was not addressed in her petition. So we didn't have notice that she was requesting that. This is something that the hearing officer did on her own. So without notice that this was going to be an issue, we did not respond. That violates our due process rights. That is not permitted. There has to be notice of the claims. Now, the staff attorney has made a number of issues. Habitability is specifically addressed in Civil Code Section 1941.1, and it spells out what the issues of habitability are. Harassment and quiet enjoyment do not fall within that statute. Then they argue housing services. Quiet enjoyment and harassment don't fall within the definition of housing services. These are not housing services. They may be authorized by law in a separate action or proceeding, but it doesn't fall within the confines of this ordinance. The unlawful rent issue is very clear. The Constitution, Article 1, Section 9, specifically states, there shall be no impairment of contracts. Now, each year from the first year after her term was up, we gave her a lease renewal agreement. She signed it. That renewal agreement specifies what the rent will be. The ordinance attempts to impair that contract by rolling it back. That can't be done. That's not allowed. And the Constitution preempts local laws. It is superior. If the Constitution says you can't do something, a local ordinance can't contradict it and say, oh, yes, you can. And that's exactly what this ordinance does. Now, the presentation by staff attorney says, well, we're trying to declare the whole ordinance unconstitutional. That's not true. We're only saying this portion of the ordinance is unconstitutional. And pursuant to the ordinance, if there's a partial invalidity, the remaining portion of the ordinance stays in effect. So we're only challenging the rollback that impairs our contracts with our tenant. There are inconsistencies in her testimony that we challenged during the hearing that seems to be overlooked by the tentative decisions. We challenged it throughout the hearing, but those have not been addressed. The property was registered in 21 and 22. However, through a clerical error on my part, I did not keep copies of the registrations. However, we did pay the fees, and that's undisputed. The bottom line is that this decision is not sustainable. We ask that each of you read our response to the committee's tentative decision, which really spells out in great detail what our position is. Now, at this point, I want to submit for the record copies of the following documents that we've already submitted, but I want it part of this record is our petition response.
Sir, all of this is already part of the record, and the Rental Housing Committee has been provided with the entire record.
Yep, we have the whole record and also the recordings of the hearing and all the documents submitted in the record.
Well, these are
But also,
identical documents.
just for the benefit of the people online, speak of the microphone. They can't hear you. They can't hear you on the recording.
Oh, I'm sorry.
YouTube.
I'm sorry.
There you go. Thank you.
I want a part of the hearing record. I don't want there to be any question that these documents are part of the record. And
If it is in the hearing record, then it is in the hearing.
I'm not positive everything is. That's why I'm going to present it tonight. Is our petition response form, our response to the petition, the response to the amended petition, and the supplemental filing that the hearing officer wanted us to submit, the written decision of the hearing officer, and our response to the tentative decision. These all should be part of the administrative record. Now, I'm not going to go through everything that was in our response to the tentative decision. Frankly, don't have enough time. So, again, this decision is not sustainable. If there are any questions, I'll be glad to answer any questions any of you may have.
All right. Thank you.
Okay.
It is now time for the respondent tenant. Please come to the lectern if you are speaking in person. The speech timer will be displayed on the screen. You'll have 10 minutes.
We're going to be providing 20 minutes to account for translations.
You will have 20 minutes.
Buenas noches. Yo no quiero hablar mucho, pero referente a lo que dice que yo dije de que no lo hacía por dinero, es verdad que dije yo que no lo hacía tanto por dinero, pero estoy haciendo esto más bien para darle a él una experiencia de vida, porque También es verdad que yo me moví 2 meses antes de que el contrato terminara porque mi salud iba de mar en peor. Y cuando yo le pedí ayuda a él, al dueño, él estaba como en complicidad con la persona que me estaba haciendo daño. Por ejemplo,
Good evening. It's true that I said that I wasn't just doing this for money, but I was doing it for a better quality of life. And it's true that I moved out 2 months before the end of the contract that I had signed, but the reason for doing so was that my health was getting so bad that I had to move out. And I also found that the landlord was cooperating with the person that was harassing me.
cuando yo fui a pedir ayuda al programa en Calle Escuela, me recomendaron una abogada para negociar. Yo le suplicaba a él que yo quería las cámaras y el señor no quería que yo obtuviera las cámaras después de 2 años. Yo estaba en pánico. Entonces, él le dijo a mi abogada que él nunca me había dado permiso y sí me había dado permiso. También la señora y él me han mandado cartas diciendo que venga y pare esto, porque como yo dije que yo no lo estaba haciendo por dinero.
So I went to get help from Calle Escuela so that I could get legal aid. And I asked for permission to put some cameras up, and they said that I never asked for permission to put cameras up, but I actually did get permission to put the cameras up.
La abogada que me estaba ayudando a negociar por las cámaras, ella me dijo, no te preocupes, este señor está actuando muy mal contigo, vamos a hacer un plan. Porque no te quiere dejar las cámaras, es algo simple, es para tu seguridad. Le di cartas de un psiquiatra donde le dijo que me dejara las cámaras porque yo estaba sufriendo.
So when I spoke with the lawyer to ask for help to enable me to negotiate to keep the cameras up, she said, don't worry. The landlord is acting in a very bad way. Let's come up with a plan so that we can try to keep the cameras up. So she said you should see a psychiatrist because your mental health is really suffering.
El plan fue, como el señor no quería cooperar conmigo, el plan fue de pedir el aumento de rentas de regreso para darle una lección de vida a él. Yo estoy bien con la decisión que dio la juez. Para mí está bien, es suficiente.
So we came up with a plan because the landlord didn't want to cooperate. So we asked for the interpreter needs clarification. El plan fue para aumentar la renta.
Para esto.
Oh, yeah. So the plan was to ask for a hearing to solve this issue, and I'm very happy with the decision of the judge.
El señor dice de él siempre que pasaba una situación en el vecindario mandaba cartas a todos. Pero el dueño dice que cuando yo les dije que estaba sufriendo por acoso, dice que él habló con el vecino, pero nunca nos mandó cartas. Yo trabajé 18 años con una familia en Palo Alto como empleada doméstica y yo nunca sabía que el acoso era ilegal. En mi trabajo limpiando la casa, cuidando niños. Nadie me dijo que esto era ilegal. Yo me di cuenta por mi trabajadora social, pero él sí sabía que esto era ilegal y aún así él no actuó.
The interpreter needs clarification. Le envió cartas a quién?
Cuando pasaban situaciones en el vecindario, el dueño enviaba cartas de lo que pasaba
¿Usted con usted?
a todos. Pero cuando yo pedí ayuda, nunca hubo cartas diciendo que yo estaba teniendo el acoso.
Oh, okay. So sometimes the landlord would give out letters to the apartment complex talking about certain situations that were happening. But when he found out about the harassment that I was experiencing, he never sent out any letters saying that this was an issue in the community. And I've worked for 18 years for a family in Palo Alto, taking care of their kids and cleaning their home. And during all this time, I never knew that harassment was illegal. I had to find out on my own through my social worker.
También en mi comunidad, cuando una persona va a una casa y se lleva algo sin permiso, eso se le llama robo. No importa que si lo compró o no lo compró, como sea el caso, en mi comunidad, eso es robo. Yo nunca he ido a un lugar a llevarme algo sin permiso.
Where I come from, in my community, anytime that somebody takes something that doesn't belong to them and they take something from you, we call that theft. It doesn't matter if they purchased it or not. When you come to somebody's home and you take something, we call that theft.
Aún estoy en un tratamiento. Voy con un psiquiatra, con mi trabajadora social, con el doctor. Estoy bajo medicamentos por todo lo que pasé. Yo quiero terminar con esto.
I'm under treatment. I have ongoing treatment that I'm taking.
I know you're tall, but
Oh, sorry.
can you hurt your
Sorry
mic?
about that.
There you
okay.
go.
I'm going through a treatment and therapy, not only with my psychiatrist, but with my social worker as well. And I'm taking medication to help me get through this. And I really just want it to be over with.
El Señor, después de 2 años tener cámaras, me hizo bajarlas y Él estaba, me llegaba a mi casa a tocar la puerta, a gritarme que bajara las cámaras y todo eso me aterraba. El agresor a un lado se carcajeaba cuando el Señor llegaba a tocarme, a gritarme, baja las cámaras porque si no las quitas ya no te voy a correr, ya no te voy a firmar el contrato. Yo mandé un video, no sé si lo pudieron ver, donde él insistía. Yo le decía por texto, mi hijo le decía, mi mamá no puede verte, se siente muy mal, está sufriendo ataques de nervios. Y el Señor insistía. Por eso estoy haciendo esto, para darle a él una lección de vida, para que él no vuelva a pasar esto con nadie más en mi comunidad y en el vecindario.
So after 2 years, I had the cameras up, and this man told me to take them down. You can't have them up. And he would yell at me and pound on my door, telling me to take the cameras down. And I made a video. I don't know if you were able to see it, but there was a video of one of these situations. Also, he would send texts, and my son was traumatized by this, and one of the reasons why I'm doing this is so that my son won't ever have to live through anything like this again.
Finalmente, tuve que bajar las cámaras con cable y me hizo comprar otro paquete de cámaras inalámbricas y tuvimos con mi hijo que poner tape porque él quería tape. Eso fue muy, muy doloroso para mí porque mi agresor estaba viéndonos y se estaba burlando y al Señor no le importó mi economía, no le importó mi sufrimiento, no le importó que ver cartas de un psiquiatra diciendo que estaba sufriendo, no le importó que tener una abogada, él no le importó mi salud, no le importó que yo soy mamá soltera. Y yo solamente estaba haciendo lo mejor que podía, aunque vivía unas situaciones difíciles, yo hacía lo mejor. Mi hijo, gracias a Dios, ya se graduó y es un buen ciudadano.
I finally had to take down the cameras and put up other cameras that were wireless, and I had to use tape to put them up. And the landlord didn't care that I was suffering. He didn't care that my economic situation. He didn't care that I had letters from my doctor. He didn't care that I had a lawyer. He didn't care about my health. And
You don't have to object. My understanding is
You will have time to rebut
I will rebut.
very,
I
very
won't
shortly.
object, because my
That
understanding
is,
this, our testimony was supposed to be
we have a period for
with the
rebuttal.
hearing record, based on the hearing record. She's just testifying regarding stuff outside the record.
Sir, we will give direction to the RHC on how to consider what's being discussed.
Okay. He didn't care that I'm a single mom. I'm doing the best that I can, and thank God that my son was able to graduate. And yeah.
Y nosotros, mi hijo y yo, tenemos muchos años sirviendo a una iglesia y también mi hijo sirve en la policía, ayuda también ahí. Esto nada más para decir qué tipo de personas somos. Gracias.
Me and my son have spent many years at the same church, and we volunteer there. And my son also helps out with the police force. And I'm only letting you know this to give you an idea of what kind of people we are. Thank you very much.
All right, thank you. Now, the appellant landlord, you have 5 minutes to rebut any statements made by the respondent. Please limit your comments to rebuttal rather than repeating information already presented.
Okay, Ms. Garcia falsely stated that we cooperated with the tenant that was bothering her. That is false. We told him to stay away. We never cooperated with him in any respect. We also told her to call the police and file for a restraining order. Why she waited 2 or 3 years to do that, I don't know. My wife doesn't know. But we never cooperated with the neighbor. We told him to stay away from her. As far as the camera is concerned, she said that we could not put up a camera. That is, again, false. She presented at the hearing a text message from my wife saying, yes, you have permission. That directly contradicts what she just said here. The problem we have is that when she put up the cameras, she drilled holes into the stucco, the exterior stucco of our building, thus affecting the waterproofing of the building. We have a problem with that. She also drilled into the underside of the roof overhang. thus affecting the roof structure. Not so much the structure, but water penetration. Yes, we have a problem with somebody damaging our property, and we told her, take it down. And that went on for about 5 months before she finally did it. And that was all during that time. I kept asking her, let's meet, let's talk. She refused to meet with me. Finally, she had her son involved. He and I met at the property. We discussed the issue, and we agreed upon where she can put the cameras and how she can put them up. That apparently wasn't good enough for her. She wanted to leave it with holes in our building. That's not acceptable. This is the problem we're having with her, is that she's saying whatever comes into her mind, whether it's true facts or not. And this is what happened during the hearing itself. And we contradicted or disputed a lot of what she said. And the hose issue, she was not entitled to use the outside water spigot, but she kept doing it to a point where she had planted vines that were crawling up the exterior of our building. And if you ever had an experience with vines growing on a building, they're very hard to take off, and they leave parts on the building unless you scrape it off with a wire brush. And then you have to repaint. The bottom line is we tried working with her, but she didn't want to work with us. She wanted to do it her way. As far as her claims, they're baseless. They are just absolutely baseless. I cited a number of authorities, legal authorities in our brief. Those are laws governing proceedings in California. They're not just limited to legal actions in Superior Court. They are the law of the state, just like the Constitution is the law of the state. And this committee has to follow what those laws say. So again, if you have any questions, I'll be glad to answer anything.
Thank you. So, respondent tenant, you now have 5 minutes plus 5 minutes for translation to rebut any statements made by the appellant. Please limit your comments to rebuttal rather than repeating information already presented.
Cuando instalé las cámaras, yo contraté a una persona y fue un clavito muy pequeñito. No lo hicimos nosotros. Para quitarla sí. Y no fue algo, no dañé la propiedad. Y me hizo comprar un galón de pintura para el pequeño puntito que dejó, tener que pintarlo.
I contracted somebody to install the cameras, and when they did so, they left a very small hole during the installation. And afterwards, when we had to take the cameras down, I bought a gallon of paint so that we could try to fix those tiny little holes that were in the wall.
Solo eso quiero mencionar. Yo ya hablé y no quiero estar repitiendo todo porque también eso me hace recordar todo lo que pasé y no quiero recordar tanto.
That's really all I wanted to mention. I don't want to just repeat myself, and I don't want to rehash all of these old memories because it causes me a lot of stress.
Thank you. All right, now it's our turn. So, RHC members, do you have any questions for staff? All right, Robert?
Yes, I wanted to follow up on the comment made by the appellant landlord, okay, about, that he was denied due process because he wasn't told that, rent rollback would be part of the hearing proceedings. And I went through, I'm looking through the list of the issues that were raised on appeal. I don't see that one listed there. Is it listed there and I'm missing it? If it is there, and can you maybe comment on your thoughts?
Yes, thank you. So first of all, this is the first this issue has been raised that I've heard of. And as we discussed at the beginning of this hearing, the appeal is limited to the issues that were raised on appeal. That being said, I would just note that the rent rollback was listed in the petition. It was very specifically, the box was checked. There was additional information that the petitioner filled in the petition about the fact that there had been no rent rollback. So there was ample notice, and it was discussed at the hearing.
Sir?
Okay, that's my only.
I do have a gavel.
Thank you.
Mark?
Yeah, thank you. I had a similar question, but actually to something else. I thought I heard the landlord say that there was a surprise claim on the rent increases being more frequent than 12 months, and so they did not have the opportunity to prepare a defense or evidence. Can you address whether the claim and the examples in the record here for rent increases more frequently than 12 months, was that originally part of the petition, and how was that noticed so that the landlord would be able to respond to that?
So it was not specifically listed in the petition. What I do want to make clear is that issue really has no impact on the ultimate decision because the rent was rolled back to the base rent. So, but the hearing officer did go through the rental history. At the hearing, the tenant presented a schedule of rents paid and a rental history. The hearing officer specifically requested the landlord, do you disagree with this? And the response was, no, it looks about right to us. So it was based on that evidence that the hearing officer concluded that there had been rent increases, because if you go through that month by month, there were periods where the rent increased after 10 months sometimes. So that was the basis.
And a follow-up question, were any like service notices or other subsequent to the original lease, were there any notices or new leases or rent increase notices provided as evidence in the process?
So what was testified to at the hearing by the landlord was that the landlord renews leases on an annual basis and sends the tenant a new lease. Several years of the renewed leases were part of the record, although not every year. There was not evidence in the record of an actual rent increase notice beyond those leases.
Okay. But what you're saying, though, is that either way, this really is trumped by the rollback issue.
Right. So this isn't an issue where some rent increase was disallowed because it violated the CSFRA. I think the hearing officer was embellishing on the rent history and going through all of the issues that the rental history demonstrated, but the rent was rolled back to the base rent.
Okay. And then last question, the landlord talked about multiple, damage in terms of drilling through the stucco. Were there any, was any evidence put into the record of formal notices, quit notices, anything like that to the petitioner due to damage to the property?
I don't recollect any notices to that effect. There was evidence in the record that the landlord requested that the petitioner remove the security cameras. There was some back and forth on that, and then there's evidence from the petitioner showing that they did actually remove them and that they did repair the holes in the stucco. So.
Okay, thank you.
All right. Edie?
Thank you. So
This appeal has got me thinking about the early days of the CSFRA, and there were existing leases in effect when the CSFRA was passed and then went into effect. And I'm just curious if you could comment on the legal interaction of the CSFRA and the existing leases and the requirements.
Yes. So I think the issue that is being raised here is whether the rent rollback constitutes an impairment of contract. And there is a prohibition against an impairment of contract, but that prohibition is not absolute. And there's a long line of cases, some of them involving rent control, some of them involving other instances where government action results in the impairment of private contracts dating back to the Depression, having just had to read these cases today. So, the courts have basically, there's no longer a strict anti-impairment of contract. If there's sufficient public purpose, a contract can be impaired. And that on that basis, rent control statutes and ordinances and charter amendments similar to Mountain View have been upheld by the courts, including those that include rent rollbacks. So it's pretty well established that a rent rollback does not impair an existing lease contract.
Thank you.
All right. Any more questions for staff? So we'll move on to questions for either the appellant or respondent.
Were there any things in the testimony that we need guidance on to accept or not accept?
Yes, thank you for that reminder. So there were a couple things in the testimony, both from the appellant and from the petitioner, that raised or addressed issues that are not in the record, including one of which we've discussed. The appellant raised the issue that they claimed they were not given due process about the rent rollback issues. That has not been raised previously. The petitioner raised a lot of factual history, some of which is not in the record. As we've discussed in prior appeal hearings, your decision has to be based solely on what was in the hearing officer's record and not on new evidence. So you should disregard anything that was not actually in the record.
All right. Does anyone have any questions for the landlord or tenant? All right. The RHC will now deliberate. It would be appropriate at this time to entertain a motion to adopt the tentative decision, after which time such motion can be discussed by the RHC. Robert?
So I'm going to make a motion to accept the tentative appeal decision in its entirety. And I want to thank staff for going through this very thoroughly, going through all the multiple points that have been raised. For me...
real quick, can we get any second?
Okay.
The motion made by Robert and seconded by Edie.
Okay. So I just wanted to make a couple comments, to underline a few things. During my time on the Rental Housing Committee and also, in previous positions that I've held, I've heard and had a lot of contact with the community, and the issue of the constitutionality of rent control or provisions within the CSFRA have been a frequent issue of discussion that's been brought up, and I just want to underline what was said in the tentative appeal decision, that things like this are not a matter for us to decide. These are a matter for the courts to decide. And so that if you feel strongly enough, that's where you need to take it to get an answer on that. But I also want to concur with what we just heard from our lawyers, that this isn't, rent control is not a new thing. And because it's not, you probably would face an uphill battle in trying to get a ruling of its unconstitutionality or even the rollback through the courts. So anyway, but fundamentally, I think it comes down to this, and it's a question of whether or not, the harassment ends up constituting something that is effectively, not allowing the person to enjoy a habitable unit, or whether even it comes to the point of reducing the value of the services. And to me, that's kind of a really fundamentally obvious thing. It really does. I mean, and if we go back to what the habitability and the reduction in services clauses in the CSFRA are there for, I mean, there's a fundamental intuitive understanding that, a person comes into a unit believing that he has a normal unit. And part of that, having a normal unit and being able to enjoy that is the quiet enjoyment of the property. And as was pointed out in the tentative appeal decision, that this is something that's fundamental to all leases, and so in California. So I think that's really where the rubber hits the road with this. And so I do believe that the CSFRA is meant to address this. And as it is, that's why I support upholding the tentative appeal decision in its entirety. Thank you.
Mark?
Yeah, thank you. I think about two layers of law here that are concurrent and that have effects on each other. There's the CSFRA and there's California's general tenant landlord regulations. Many of the topics around the CSFRA have already been talked about. It passed with 54% of the voters. Ultimately, it's the voters who have to decide what is going to be acceptable way to run a society. And if there's a challenge to that, it's either through the courts, and there is a court challenge option here, or things have to go back to the voters. One of the challenges of the CSFRA is that the Rental Housing Committee has a very narrow lane to follow, and we have very little latitude. That was intentional in the creation of the CSFRA, and the voters did approve that at 54%. With regard to landlord-tenant law in California, there are a lot of questions that are raised, but it's it seems to be beyond what was put into the record. But certainly, if there's a concern around property damage, if a tenant is drilling into walls, not repairing them properly, there are legal options to be able to serve notices, quit notices, to either compel that to be fixed, or to go through an eviction process to have the have the person move out if they don't take care of the property per the lease. Same thing around getting legal advice. If there is a really unfortunate dispute between residents, it puts the landlord in a very difficult position because you're trying to get two people who are not you to live together without major conflict, but ultimately the police might have to be involved. And ultimately, according to California law, as I understand it, there is a responsibility on the part of the landlord for that. With respect to, there are some issues around whether the registration fees were paid or not. Beyond evidence of the payments themselves, something I'd be looking for would be some sort of paper trail, anything in writing of that. So there is a substantial burden of being in the rental business to maintain these records. There are processes like this can happen when when those records aren't available. So given what's in the record and given the latitude that the Rental Housing Committee does and does not have, I also support affirming the decision.
Thank you. Any more comments, deliberation? Vice Chair?
Thank you, Chair. I agree with Committee Member Balch that our role as the RHC and as the hearing officer's role as acting as for the RHC are limited by what the CSFRA dictates. and that if there are other things that are legal issues, they can be addressed in a separate legal venue.
Edie.
In various things that come before us, I find that I have a learning curve, and the part of my learning curve that I appreciate is just the clarity I now have that quiet enjoyment is part of an inherent right of tenants, and the landlord role in ensuring that. Thank you.
All right, and before we do the vote, I wish that we were the California Supreme Court, but this gavel is, I mean, it's mine. I brought it. We only have so much power under the CSFRA, and one of those powers is not declaring things constitutional and unconstitutional. So, like my colleagues, I think I'm going to have to agree to affirm the tentative appeal decision, given all the evidence. So, I think it is time to kick off the vote, please. The motion was moved by Robert, seconded by Edie, to adopt it in its entirety. And the motion passes unanimously. All right. Which means we'll move on to excuse me? Karen?
It'll be sent out by the end of next week.
So the question was asked from the audience when the written decision will be sent out. I'm not seeing the script for 5.2. Oh. That's 5.1. Okay. So we will now move on to agenda item 5.2, appeal hearing officer decision for petition number C23240065, starting with the staff presentation.
Yes, thank you. So purpose of this item is to consider the tentative appeal decision and either accept the tentative appeal decision or modify the tentative appeal decision with instructions to staff citing appropriate evidence in the record to support any modifications. This is going to be the same schedule that you just went by at the last hearing, but start with staff's presentation, followed by presentation by the appellant, 10 minutes, then a presentation by the respondent of 10 minutes, and then each party will have 5 minutes for rebuttal, followed by RHC questions for staff, and then RHC questions for the appellant and respondent, and then finally we'll conclude with your deliberations and a decision. So I'm assuming that you all are okay on the rest of the issues related to your role, so I'm not going to repeat those and just going to jump into the petition. So a summary of the petition: this was a petition for downward adjustment of rent based on a decrease in housing services and or maintenance by the landlord. Specifically, the petitioner asserted that the respondent landlord failed to find a permanent solution to the issue of a slow draining sink in the petitioner's bathroom. This is a summary of the petition process. I don't think we need to focus on anything specifically here. So a summary of the hearing officer's decision. The hearing officer concluded that the petitioner had met his burden of proof, that respondent had improperly reduced housing services and or maintenance by failing to find a permanent solution to the recurrent problem of the slow draining bathroom sink in the petitioner's unit. As a result of this reduction in housing services or maintenance, the hearing officer ordered a 4.125% reduction, or $93.84 per month rent reduction, beginning from March 11th of 2024. So for the period from March 11th of 2024 to August 20th of 2024, which was the date of the hearing. The hearing officer ordered a rent refund of $496.44 and provided that the monthly rent reduction would continue until the landlord permanently resolved the sink issue. Slide, please. I think there's one more slide before this one.
My apologies, having some technical issues over here.
No worries. Yes. So in addition to the rent reduction for the decrease in housing services and maintenance, the hearing officer also ordered that a rent increase that went into effect on August 19th, 2024 was nullified. This was because the hearing officer determined that the respondent's improper reduction of housing services and or maintenance meant that the respondent was not in substantial compliance with the CSFRA when they imposed the rent increase, and also that the rent increase was imposed prior to the expiration of the initial term of the petitioner's rental housing agreement. As a result, the hearing officer determined that the lawful rent after the respondent had corrected the issue for the unit would remain at $2,275. So the appellant respondent, who's the landlord in this case, raised the following 5 issues on appeal. First, that the hearing officer erred or abused her discretion by concluding there was a reduction in housing services and or maintenance. The appellant's main argument here is that the speed at which the sink drained did not result in the sink becoming unusable by the petitioner, and that it did not create any other issues like excessive humidity or tainting his water supply. The second issue is that the hearing officer erred or abused her discretion in awarding a 4.125% rent reduction. And the appellant's argument here is that this amount is excessive, punitive, and likely to be more than the amount of rent reduction awarded for other issues that are more significant in other petitions by other hearing officers. The third issue that the hearing officer raises on appeal is that that the appellant raised on appeal is that the hearing officer failed to provide guidance or metrics as to when the issue would be considered resolved. The fourth issue is that the hearing officer erred or abused her discretion in nullifying the August 19th, 2024 rent increase because it was not contested in the petition and because there was a provision in the rental housing agreement allowing for the imposition of rent increases during the term of the petitioner's rental housing agreement. And finally, that the hearing officer exhibited bias toward petitioner during the hearing, indicating that she would rule in favor of the petitioner regardless of the evidence or testimony put forth by respondent. So the tentative appeal decision recommends affirming the hearing officer's decision in its entirety. The hearing officer did not err or abuse her discretion by concluding that there was a reduction in housing services and or maintenance. Appellant's argument misunderstands the basis for the hearing officer's decision. The hearing officer's decision was based on a reduction in maintenance and repairs, not on the failure to maintain the sink in a habitable condition. And there's substantial evidence in the record supporting the hearing officer's conclusion that the respondent failed to seek a permanent solution to the recurrent problem of the slow draining sink. As a result, the hearing officer awarded a downward reduction beginning March 11th, 2024, which was when the appellant indicated that they would no longer be taking any actions to repair or address the issue because they did not believe that there was an issue. And so no change to this decision is warranted based on this appealed element. The hearing officer also did not abuse her discretion in awarding a 4.125% or $93.84 per month rent reduction. Under the regulations and the CSFRA, hearing officers have discretion to determine the amount of rent adjustment attributable to each decrease in housing services or maintenance. The hearing officer satisfied the requirements of the CSFRA and the regulations by explaining her methodology, which led to the amount of the rent reduction. And most significantly, the respondent did not offer any alternative methodology or that would have been appropriate to use or a more appropriate amount of a rent reduction at the hearing or on appeal. So no change to the hearing officer's decision is warranted for this appealed element. The hearing officer's decision did provide guidance as to how the issue may be resolved and when the condition would be considered resolved. The hearing officer's decision outlined several actions that the respondent could have taken and could still take to find a permanent solution to the issue, including trying an acid treatment that was recommended by one plumber, replacing the type of sink or the type of drain that was being used, as well as other recommendations that were made by professionals or that were made by the petitioner. The hearing officer's decision also clearly states that the issue would be considered resolved when the sink is functioning properly, which means that the water drains while the faucet is running 100% of the time. So this is the standard against which the slow draining sink issue would be measured in order to determine whether the issue was permanently resolved. And as a result, no change to the decision regarding the rent refund is warranted based on this appealed element. The hearing officer also correctly concluded that the August 19th, 2024 rent increase was improper and therefore invalid. The appellant argued that this issue should not have been considered by the hearing officer because it was not raised in the petition. The rent increase was noticed and imposed after the petitioner filed their petition, so there was no way for this issue to be raised at the time that the petitioner filed their petition. In addition, the rent increase was relevant as it was an update to the information that was requested in the petition and provided by the petitioner as to the current rent for the unit. And finally, the regulations, CSFRA regulations require the hearing officer to establish the current lawful rent for the unit to ensure that the amount of rent reduction that is being ordered, as well as the rent to which the level to which the rent can be restored after the issues are corrected, are accurate and correct. So it was necessary for the hearing officer to ask about or receive information regarding the rent increase. There's also nothing in the CSFRA that limits a hearing officer's authority to raise issues sua sponte. That's a fancy legal term for that means on her own. And so, she was authorized to raise these issues that were related of the rent increase on her own. And lack of substantial compliance with the CSFRA is a valid reason to avoid a rent increase that's imposed. As far as the provision in the rental housing agreement allowing for rent increases during the term of the petitioner's tenancy, by its own terms, this provision only applies to lease renewals, whereas this was an initial lease agreement between the petitioner and the landlord, and therefore is not applicable here. And so based on all the foregoing, no change to the decision regarding the rent refund is warranted for this appeal element. And then finally, there is no evidence of bias on the part of the hearing officer. Respondent or appellant's argument as to the bias is entirely conclusory. They put forth no factual support for their assertion that the hearing officer exhibited bias toward the petitioner or against the respondent at the hearing. A review of the hearing tape demonstrated that the hearing officer conducted the hearing in accordance with all of the requirements of the CSFRA and the regulations. And the hearing officer's decision itself is fair and impartial. For instance, the conclusion that the respondent was only liable from March 11th, 2024 demonstrates that the hearing officer did in fact consider the evidence and testimony put forth by the respondent of its efforts to address the issue prior to that date, and therefore did not hold them liable for the issue before that date. And so as a result, no change to the decision regarding the rent refund is warranted based on this appealed element. After the tentative appeal decision was issued and sent to the parties, the appellant did provide a response. The appellant's response, the major 4 points were that the tenant did not demonstrate any loss of service due to the slow draining sink, that there was no actual loss by the tenant, that the plumber who recommended the acid wash incorrectly diagnosed the problem and recommended a solution that would not have worked and would have been unnecessarily expensive, and that repairing issues is not an exact science, and the landlord repeatedly sought a permanent solution to the issue. The respondent also submitted additional evidence of their actions that were taken after the hearing officer's decision was
Technical issues? Yep.
Okay.
Just one moment, everybody.
Okay, I think I'm back now.
I think you're back now. Yep.
Okay, sorry about that. I don't know why my headphones decided to disconnect. Okay, we can go to the next slide. Oh, just one point. If the appellant does raise any evidence about these additional actions that were taken after the hearing officer's decision was issued, the Rental Housing Committee should consider these to be outside the scope of the hearing record and should disregard any of that information in reaching their conclusion on whether to uphold or affirm the hearing officer's decision. So just a quick response to a reply to appellant's response. The hearing officer concluded there was a loss of service based on the respondent's indication that they did not believe there was an issue and their failure to take action to find a permanent solution to the issue after March 11th, 2024. So the loss of service was not related to the sink draining itself, but rather the respondent's indication that they would not do any repairs or maintenance to address the issue after March 11th, 2024. There's substantial evidence that supports the hearing officer's decision that the tenant experienced a loss of housing service, mainly repairs and maintenance, as a result of the appellant's indication that they would take no further action to address this issue. Substantial evidence also supports the hearing officer's conclusion that the respondent failed to follow up on the first plumber's recommendation regarding the acid wash, or to seek a different permanent solution to the slow draining sink issue. And then finally, substantial evidence supports the hearing officer's conclusion that the respondent refused to perform repairs and maintenance after March 11, 2024, including testimony from a number of representatives on behalf of the respondent, as well as email correspondence from that date. So fiscal impact, any decision by the RHC on appeal, including adoption or modification of the tentative appeal decision, could potentially lead to litigation, which would have fiscal impacts. One of the purposes of appealing a hearing decision to the RHC is to ensure that the hearing decisions are legally defensible, and so the appeal process to the Rental Housing Committee reduces overall risk of legal liability and legal expenses. So staff's recommendation is for the Rental Housing Committee to consider the tentative appeal decision and either accept the tentative appeal decision or modify the tentative appeal decision with instructions to staff citing appropriate evidence and the record. And that's all on my presentation.
Thank you. All right. So appellant landlord, please come to the lectern if you're speaking in person. Jeff? The speech timer will be displayed on the screen. You'll have 10 minutes. Welcome. And yeah, don't forget, the mic is not made for tall people, I know.
All right, you're going to love me tonight. In the RHC, I'm the landlord, and by default, I'm going to lose anyway, so here goes. RHC is a kangaroo court stacked 3-2. There is no way to win this one, period. RHC was written by nonprofits, funded by nonprofits, advised by nonprofits, and modified by nonprofits to punish landlords. That's the way it is. There's no other way of looking at it. Every petition arriving through our office now includes some sort of reduction in service, and it's a negotiating ploy. That's just what it is now. The RHC listened to it, but I do want to thank you for the RUBS increases, because if you listened to landlords, it would have been simpler and it would have been actually in line with the actual numbers. We actually get a bonus because you guys screwed up that petition. So thank you. As a result of the RUB stuff, though, we do rent to the fewest number of people as we possibly can to minimize our costs. And I'm going to get to the petition at some point. And I hope you like my records request, because if you keep picking on me, I'm going to keep doing that too. So, new sink and drain pipes were installed October 17th, 2024. Demonstrated to be working properly. I did submit that to the RHC as part of the appeal process. We essentially replaced a brand new sink and drain installed at the beginning of the tenancy with a brand new sink and drain. Repairing issues is not an exact science. Some are analogous to making when your car makes a noise. When you bring it to the mechanic and they can't figure out, eventually we do get it. We had demonstrated multiple times that it was working, and it did work, and then sometimes it wouldn't. That's what happens. Go back to what I said earlier. We replaced a brand new sink with a brand new sink. And we put a stopper in it this time because that's what the tenant said during the hearing, that he wanted a traditional sink with a stopper. Yay. Of course, I lost my place now. Damn it.
You've got 8 minutes. Take your time.
That's all right. We had multiple trips, multiple maintenance guys, and mostly because eventually we found out the tenant wanted a sink with a stopper. It cost us thousands and the tenant $0 to give him that. Plumber who recommended an acid wash, as cited in the arbitrator's decision, incorrectly diagnosed the problem and recommended a solution that wouldn't have worked and also would have been disastrous for the company. It is called a muriatic acid. It is known to significantly corrode cast iron pipes and will eat holes in the sewer pipes in less than 5 years. Now, what buildings have iron pipes? Anything that is 3 stories or greater, including my building, have cast iron pipes. If I would have done the acid wash that plumber recommended and that arbitrator said I should do, I would have destroyed my sewer line. Hundreds of thousands of dollars. And not to mention displaced tenants in that process. A tenant requested a $500 reduction in service. Where did this arbitrary amount come from? Likely suggested by RHC staff, to be high enough to punish a landlord, and it frankly is, over a slow drain, periodically, by the way. I don't know if you guys read the thing. It wasn't all the time, it was periodically. So, when I say did not demonstrate a loss of service, the sink did not leak underneath. The sink did not leak onto the floor. The sink did not flood the bathroom. The sink did not take any longer to fill the basin. The sink did not make any noise. The sink did not require excessive cleaning. It did not take the tenant longer to brush his teeth. It did not take him longer to wash his hands. It did not take him longer to shave. It did not cause extra fog in the mirror. Didn't have to scoop any water out of the bowl. Didn't have to siphon any water out. What do you do when you're at home? The same thing I do when I'm at home. What do you do when the sink is draining? You turn off the faucet, you walk away. Is that a reduction in service? Does it matter how fast or how slow that drain goes? Does it? No. If it's draining slow, you walk away and it still drains. You drain fast, you walk away, doesn't matter. Do you ever pay attention to that? I don't. Probably never will. Just so you know, we actually took that we took the one that was installed when he first arrived there in his tenancy, we put it into another unit. It's operating perfectly, no issues. Tenant hasn't complained, no service issues, nothing. This was like, it's not like a broken window or broken door that doesn't work. Essentially, a door occasionally would close a little slowly when it's cold. That was about it, but it actually worked. So what was the actual tenant's loss? 0. Nada, nilch. There was no loss. He still had a working sink, period. I'm going to say it. And I said all that, and I'm going to say it again, like, I'm going to recap this. I'm going to lose. I full on know that. I fully accept it because it's a 3-2 vote, and I'm screwed either way. But I'll be here to answer questions later.
Thank you. So, respondent tenant, please come to the lectern. The speech time will be displayed on the screen. You have 10 minutes. Welcome. Also, yeah, tall person. The mic is not made for you.
Is that good? Okay. So yeah, to briefly recount, tilt my head.
If you tilt your head towards it.
Oh, okay. So I can speak into it. Sure. So to, I guess, give an overview of the issue that I was having was shortly after I moved in, I noticed an issue where water would fill up in the basin of the sink. And so, like we talked about in the hearing, I filed several maintenance requests. And I noted it happens some of the time, not all the time. And my landlord kind of made it seem like it wasn't a big deal. But like the videos I showed during the hearing, it was an above top sink that came up about this tall, was this big. Many times it would just be completely full of water. Like you could like wash a small animal in there. And so that was definitely a problem for me because, I mean, like in the last appeal, you mentioned something, you know, you expect a normal apartment when you move in. I expect, like, when I brush my teeth, I shouldn't have to spit out toothpaste into like a large vat of water that then slowly drains, and then there's toothpaste all over the sink. That's like kind of dirty and just not what I'm paying rent for. So to go on to like his appeal, yeah, the tenant does not have to watch and sit the water drain. He can walk away and let it drain on his own. It doesn't impact his ability to use the sink at all. So like I just said, it does impact my ability to use the sink because it makes it get dirty almost immediately. And that happens from washing your hands. Just normal stuff that you put in the sink is supposed to go down the drain quickly, not just sit on the surface of the sink to evaporate. And that's what was happening with my drain. What else was I saying? The other thing I wanted to talk about was, so I think what the hearing officer ultimately concluded was enough to give me an award was that they decided that just to stop doing the maintenance on my sink. And so in March, I received an email that they said, we called the plumber, a professional plumber out twice, and that's enough, so we're not going to anymore. However, yeah, like the things that the pro plumbers were saying, I believe are enough to just show that, you know, he wasn't really that serious about fixing it anyways. He was going through the efforts to, like, the motions to satisfy his responsibilities as the landlord. But if he was really serious about fixing the sink, he could have I like talked to the plumbers a little bit more, followed up with me. I mean, the entire time I was explaining, like, even though maybe one day when the plumber came or his maintenance staff came, the water drained fine. The next day, and I had videos of this that I showed in the hearing, it would be filled up to the top again. So yeah, I mean, he basically wasn't really trying to fix it. He was just going through the motions of calling a pro plumber. So yeah, so what else do I want to talk about? The rent increase, Yeah, like my understanding of the CSFRA is that if they are not in accordance with it, they're not allowed to increase the rent. So I believe that is enough for the hearing officer to roll it back. And I also want to talk about the issue with my lease not being up before he raised the rent. I actually contacted him after he gave me the notice to raise my rent, because he tried to do it 2 weeks before my lease ended. And his response was that there is a clause in the lease, and I think this is in the tentative appeal decision, that allows him to raise it. It says specifically something like, if this is a lease renewal, we are allowed to raise the rent after 12 months. However, obviously it's my first lease there. I was not renewing the lease. What they argued was gave them the authority to raise it after a year was because at the top of the lease, they titled the document lease renewal. That doesn't really seem like that's how that should work to me. But beyond that, I don't think that really matters, because like I said, if the hearing officer found that he wasn't in compliance with the CSFRA, I don't think he was allowed to raise the rent anyways. And yeah, I guess the last thing I'll talk about is in his response, he had a good analogy where repairing some issues is not an exact science. Sometimes it's analogous to your car making a noise and the mechanic not being able to figure it out. And I think that's a good analogy, but I think it's more like a car that you buy from a dealership and it's under warranty, because you buy a car that's supposed to work for a year. And if you take it back to the dealership and they just say, oh, that has a problem, but we don't know what's wrong with it, and they just give it back to you, that's not your purchase contract. You have an agreement that you have to have a car that works, and they have to keep trying to fix it until it works. Sure, you can, you can give them plenty of time to try and fix it, as long as they keep trying to. But I think my landlord stopped trying to fix my sink, as he clearly said he did in an email he sent to me in March. Thanks.
Thank you. So now time for the appellant landlord. 5 minutes to rebut any statements made by the respondent. Please limit your comments to rebuttal rather than repeating information already presented. Welcome back.
I don't recall ever seeing any video where we could get bathe a small animal in the sink. The videos were always just a little bit of water coming up, maybe an inch or so, and then going down. I don't know how small an animal you're talking about, but that's like super small. Like I said, the reduction in service was zero. It was still usable. It still worked great. Eventually, I'm assuming we found a solution. Did it work? He's not going to affirm it because he wants his rent reduced. So I don't know.
Respondent tenant, you have 5 minutes to rebut any statements made by the appellant. Please limit your comments to rebuttal rather than repeating information already presented.
Yeah, I guess. Well, there are videos. If you guys have the record, you can see there's videos, and some of them that he showed at the end of the hearing, where there's a couple of inches of water in the sink. So, how small of an animal you can wash in that? Maybe I overstated that. A squirrel? I don't know. But anyways, answer his question, and then I also wasn't sure if I should talk about this because I don't think it was. This was after the hearing, but once the decision came out, he did come and put a new sink in my bathroom, and yeah, the issue is better now. So I think we can talk about. Well, yeah, I don't know how that would affect things. My hunch is, yeah, it was an issue with a mismatch of the water pressure and the design of the drain, and perhaps the design of the drain just made it foul up a lot easier through typical usage. I mean, I'm not a plumber, so I can't really speculate, but the problem is gone with the new drain. But again, I wish he could have installed that new sink with a better drain a couple months after I moved in.
All right, thank you. So back to us. RHC members, do you have any questions for staff? Robert? No? Just looking back to the thing. All right. Any questions for staff? All right. Any questions for Edie? Oh.
Oh, I do have a question for the appellant landlord.
Oh, okay.
Okay.
Edie, was there a question for staff?
So could you come back here to the podium? I have a second question after that one.
Wait.
Edie goes first.
Edie, was there a question for staff?
Yes. Oh, okay, sorry.
Then you go first.
I looked at the videos in the record, and I guess I'm wondering if because a lot of them that I'm seeing are about 5 seconds long, and they don't look that severe of a backup. And is there one I miss that shows a severe backup? And could it be displayed? Just so that I can see the worst video? Is staff able to select the worst video and play it?
Patricia, do you have the videos from the hearing record available?
No, I would not have the ability to go and pull that right now.
Okay.
Okay, so now we'll move on to questions to the landlord and tenant.
Yeah, I wanted to ask the landlord a question. Can you come back so when you give me your answer, I'll be able to hear it in the microphone? Thank you. So when you said, at some point you had put in a new sink, which presumably has a new drain with it, right? At that point, if you would have run the water, would the water have backed up on a new sink, or it's something that happened subsequent to that caused this strange behavior?
Are you asking about when it was originally installed?
Yeah.
But it was installed prior to the tenants moving in, and it was a brand new sink and drain that worked properly.
Okay, and so, this is something that happened subsequent, that this strange behavior happened in the process of the sink being used, right?
It was subsequent and intermittent.
Okay, thanks. That's what my question was.
Yeah.
Mark.
Yeah, I have a question for the landlord as well, please. Following on Committee Member Cox, can you talk a little bit about when the tenant reported the problem? It sounds like you had called a plumber, there was some evaluation. What information was submitted by the plumber? What did they assess, and what options did your plumber give you? Not what you were told by the hearing officer, but what were you discussing with your plumber about remedy?
All right. So there's a couple things going on. So myself, I've got 3 maintenance guys on staff, as well as I have, as well as we called plumbers, right? So my maintenance staff looked at it multiple times, as well as I had 2 plumbers out. One of them said, you should look into doing an acid watch. That's when I called another plumber up, and I did some research on the internet and looked it up. It's muriatic acid. It corrodes cast iron pipe. It's a no-no. But we, like I said, multiple times we had multiple people out, and sometimes I would say most of the time when they showed up, it was working properly.
Did any of the plumbers try to stake the drain to see if there was anything obstructing the drain?
Oh yeah, multiple times.
Thank you.
No.
All right. I have a question for the tenant. Have you ever seen the PSAs about not running the water while you're brushing your teeth?
Yeah.
Okay. That's it. Just want to know if we're in a drought.
Thanks.
Any more questions for the landlord tenant? Edie?
For the tenant, please. Of the videos you submitted, what was the longest one? How many seconds?
I can't remember off the top of my head.
Okay.
I took a huge amount of videos and then it ended up being like too many to submit. But I did have some that were up to 30 to minute long. Of the ones that I submitted, I forget if I did that or not. Also, could I answer your question to the staff or to the?
Okay.
In the hearing video, I showed some pictures of some severe backed up sinks, and the worst one that I have here that I can see was from May 5th. And that was, I think, just an image on the slide. I would have to go back and see what the worst video that I submitted is, but.
And so the length of time that your drain doesn't drain is at a maximum?
About a minute. If in the worst case, if it's completely full, it would take about a minute to.
So the sink, understanding it's intermittent, but your worst case scenario is you have a full sink and it drains within a minute.
Yeah, but the problem is that it's filling up while the water is on. So it doesn't drain while the water is on, is the problem.
Right, so you'd have to turn the water off.
Right,
and then
yeah.
wait for it.
Exactly.
Okay. Thank you.
Oh, Mark?
Yeah, I have a question for the tenant following the last question. To your recollection, does the sink have an overflow in it? You know, the hole that's somewhere on the periphery of the sink?
This one does not.
Okay, it does not. And so did I understand correctly that you were observing if you did not turn the faucet off, it would overflow, is you're saying, because it is not draining fast enough?
Yeah, the water level was rising in the sink. I never let it overflow.
And the discussion has been around intermittent. Could you estimate how frequently is intermittent? Is it failing to drain adequately once a day, hourly, once a week?
It seemed like it would be a couple times a week at least.
A couple times a week, okay.
And then, yeah, I mean, it maybe after he had the plumber come and snake it was better for a week. And then other times it would happen every day when I got home and then run water through it. And the rest of the day it was fine. Yeah, it's happened. This is so long ago. It's hard to remember all these specifics.
Robert? Mike?
Okay. Yeah, so then my question back to the tenant is, how long was it from the time that you moved in to the first time that you noticed this problem?
I think it was September that I first moved in, or the end of September when I noticed it. It happened pretty soon after I moved in.
Like how many months after you moved in?
1 to 2 months.
Okay, thank you.
Actually, this is something that came up in the hearing. Jeff, did you ever resolve the video presented, I think, was it Prashant, that was listed as August 27th, when that was actually taken?
I don't recall.
Yeah, okay.
No, sorry.
I remember you guys had your own videos that were presented in the hearing.
Yeah, I know we had some.
And one of them was a date that was shockingly close to the move-in time, but I don't know if that, it was not in the appeal.
Yeah, I don't have anything, and I don't recall that one. What you're talking about. So a lot of it was a long time ago. Sorry.
Yeah, it's fine. I mean, Dates are hard. All right. Thank you. Mark?
I have a question to staff. Can I ask a question to staff now?
Go for it.
All right, cool. I feel like we are now dealing with statements of fact, what is actually going on, what is the judgment of the hearing officer of what is truly a reduction in service. If there's a reduction in service, what is the magnitude of that reduction to merit a refund of various, amounts of money? So we are really getting to issues of whether we're second guessing the hearing officer, whether we believe the hearing officer has reached plausible conclusions based on the evidence presented. From a process standpoint, what is the RHC's ability to operate here? Depending on what we're willing to grant the hearing officer, various conclusions could be plausible. But if we are questioning the hearing officer's determination of fact, then conclusions may not be plausible. So I'm trying to figure out, are we like, when does this become a de novo situation? When are we within our latitude to figure out what is plausible and what is not?
Okay, so two things to that point. I think it's helpful to talk about what standard the hearing officers operate under. So when a hearing officer is determining, whether or not a petitioner has met their burden of proof, the standard that they're looking at is a preponderance of the evidence. And that means, is it 51% more likely that this is happening or that it's not happening? So that is the standard that the hearing officer is looking at. So then your role as the RHC on appeal is to say, okay, was that hearing officer's decision that it's 51% more likely that this issue did exist, that there was a reduction in services, is that supported by substantial evidence in the record? If it's not supported by substantial evidence in the record, then you can overturn their decision. If it is, then you should affirm their decision. One other thing that I just want to mention here, because I think there might be a little bit of confusion as to what the hearing officer's basis for her decision was. So her decision was not based on the fact that the reduction in service was the use of the sink. Her basis for the reduction in service or maintenance was that the appellant informed the petitioner that they would be taking no further action to repair the issue. So if they complained again, and they testified to this at the hearing, they said that if the petitioner complained again, they would say that there's no issue and they wouldn't take action, or they would have to, it would be too costly for them to repeatedly have to send out a plumber to snake out the drain on a repeated basis, and that they didn't believe that there was an issue. So the basis here for the reduction in service is not that they were not able to use the sink. It was that the petitioner was informed that they would not get the repairs or the maintenance that they were seeking for this sink issue.
Thank you very much.
Last call for questions. So it would be appropriate at this time to entertain a motion to adopt the tentative decision, after which time such motion can be discussed by the RHC. Robert?
Yes, I'm going to make a motion to accept the tentative appeal decision in its entirety, and I'll wait to see if there's a seconder. Okay. So.
All right, motion made by Member Cox, seconded by Vice Chair Ma.
Okay, so here, let me give my rationale for this. I mean, I think it comes down, basically to, whether the reduction of services actually was there. Also, is this a reasonable amount for the reduction in services? And then whether or not, given there's a reduction in services, is it also appropriate to apply the inability to raise the rent until the issue is resolved? Okay, so then the first thing about it is was it reduction in services? I would say yes, there is, because the landlord owes the tenant a properly working sink. Now, I have seen sinks that have problems in backing up. I know that it isn't always easy to figure out what the quickest and cheapest way is to deal with the problem. But I can tell you that in my own house, I have 5 sinks and none of them exhibit this problem and they don't require ongoing maintenance. Now, the thing about it is that it could be a lot of things, right? It could even be something as simple as, you just bought the cheapest sink possible and it comes with all these kinds of problems, and the only way of fixing it is to get a sink that, is made by a quality manufacturer that doesn't exhibit these problems. But we're not here to try to decide that. I think it's perfectly reasonable that, the criteria that was used, that if you turn the water on, that the water is not supposed to go up, okay, even intermittently, and that the problem needs to get fixed. And the other thing is that I quote back what the tenant said. There is a good analogy with the idea of buying a car under warranty. The idea is that it isn't enough to say that I don't know how to fix the problem and therefore I don't have to fix the problem. It's just that, you're required to fix the problem or you're not providing the right amount of services. So that's my first point. Second point is the 5 1/8% reduction punitive or, excessive? And I don't think that it is. If it had been something large, like 50%, then, I would begin to question that. But we went through this process discussing whether or not there should be a schedule for particular problems and what the reduction should be. And, the RHC decided that they don't want a schedule. They want to let the hearing officer's discretion to be able to be applied. And so, I accept that decision. And, then I only feel that it needs to just be a reasonable one. And this is, I think it's reasonable because it's large enough to get the attention of the landlord, okay? But it's not so much that it's outside the scope of what, the reduction in services would merit. So I think that's fair, too. And then the last thing follows is about since there is a reduction of services, then, that does affect, the ability to raise the rent, because if you're having a non-working, if you have a reduction in services and it's not remedied, then, all rent increases are on hold until the problem gets resolved. So that's my reasoning.
All right, thank you. Mark?
Yeah, it seems like the root of this is what is a fair determination of reduction in service, and the final Q&A with staff was super helpful for me, clarifying that this was not so much about the sink draining, it was about the landlord's refusal to entertain further service, which perplexes me. Anyone who owns property, whether you're a landlord or just a property owner and you have a private house, nothing should be more scary to you than a water leak, because it'll damage and kill your house. And if a sink is not draining and someone leaves the faucet on by accident, that's really, you don't want to own a piece of property that's going to be soaking. So I am perplexed by anyone who owns property, landlord or not wanting to take seriously a plumbing issue. So if there is a fundamental disagreement about that legality, again, I would suggest that go through a court challenge. But the fact that the landlord stated apparently in the record that they were not going to service this anymore, that seems to be an uncontested fact, and that's what the hearing officer is basing on. So I approve the hearing officer's determination.
Thank you. Edie?
So, I mean, I certainly hear the frustration on all sides of an intermittent problem. And so I'm just curious about the pun intended, oh dear, downstream consequences of should we uphold this, or just, what will happen either way. And I am convinced that there is a intermittent reduction in services, which is a reduction in services. And so, can the landlord satisfy the petition or the hearing officer's judgment just by resuming the maintenance? I mean, does there need to be a permanent resolution, or is it only resuming an attempt for a permanent resolution that's required to resolve this, the hearing officer's decision, and then be able to raise rents again?
Naz?
Yeah, the hearing officer's decision says that the rent can be restored when there is a permanent solution that is made to the issue. So that might mean one attempt by the landlord to do something. It might mean 10 attempts to figure out what it is. It seems, and this should not be considered, but it seems like that's already happened. But, what the hearing officer's decision orders is that when the issue has found a permanent resolution, meaning the landlord has restarted maintenance and repairs and has been able to permanently resolve the issue, then that is when they can restore rent.
And how would you tell the difference? How long does it have to be restored before it's permanent?
So if there's disagreement between the parties as to whether, usually, the parties can come to an amicable agreement about whether the issue has been resolved. But if there isn't, then there is a compliance hearing process by which the parties can present their sides to the to a hearing officer who will determine whether the original hearing officer's decision has been satisfied.
So the landlord could, would the landlord need to take that route to establish that they felt they had permanently restored it?
No, if the tenant agrees, then there's no, if the tenant is like, yeah, I feel like it's been resolved, then they don't need to go through that formal process. But if there's disagreement between the landlord and the tenant about whether the issue has been permanently resolved, then they can avail themselves of the compliance hearing process, and that can be either party. It can be the tenant or the landlord.
And what would happen if they came to agreement that it was resolved, and then another 2 days later there's another problem?
Then that would restart the whole process over again.
Under that same petition?
No, under a new petition.
Okay. I don't have more questions right now. Thank you.
Vice Chair?
Thank you, Chair. My comments are going to kind of be a repeat of what I said on the last appeal, which is there are venues to do some things. And this is the wrong venue to the procedure that the landlord did was the wrong procedure, so that's why it comes to this venue instead. So it could have been addressed in different legal ways.
All right. And just to complete this, I do not believe that the hearing officer erred or abused her discretion in any of the cases presented in the appeal. I do think that there was guidance and metrics as to when it was resolved, and hopefully it continues to be resolved. And I do not believe that any bias was exhibited. So I'll also support the motion. Any further deliberation? Could we please take a vote? All right, motion passes unanimously. back to the main one. Would anyone like to take a short break? Yeah? All right. So take a quick break and come back at 9:20 for the rest of the items. See you then. You're going to count me in?
All right, we will resume the meeting in 5, 4, 3, 2, 1.
All right, welcome back, everybody. So we will now move to agenda item 6.1, Rent Stabilization Division Annual Update of Outreach and Education Program. Public comment will occur after the presentation item and committee questions. We invite you to submit a speaker card now if you know you'd like to speak on this item during public comment. We will begin with a presentation from staff.
Thank you, Chair Brown. Good evening, committee members. Agenda item 6.1 is the Rent Stabilization Division Annual Update of Outreach and Education Program. So the purpose of this agenda item is to provide the Rental Housing Committee with an informational update on the Outreach and Education Program, including a summary of activities conducted in fiscal year 2023-24 and an overview of activities planned for fiscal year 2024-25. The Rental Housing Committee requested annual updates to stay informed of the division's educational and informational efforts, and this presentation provides an overview of tasks completed in the prior fiscal year and offers a roadmap of those to come during this current fiscal year. You received a similar presentation during the January 2024 meeting. Effective communication and outreach are vital to ensuring rights and responsibilities are understood, implemented, and accessed accordingly by tenants, landlords, and the community at large. Therefore, we focus a significant amount of staff time and effort on effectively executing our outreach and education program. Materials and communications provided by our division are created with the intent to maximize understanding of the tenant protection laws and other laws and ordinances relevant to the work that we do in the community, and to do so as clearly as possible. We routinely assess and reassess these materials and outreach methods to increase engagement and accessibility, including language access. Many of the materials that we provide are translated into the 3 other languages other than English spoken by the majority of community members in Mountain View, including Spanish, Mandarin, and Russian. So really quickly, we have a program goal with objectives and strategies to support the goal. And the goal is to increase community awareness and understanding of the tenant protections in Mountain View. And we do that through 3 objectives. The first one is to develop consistent materials that clearly communicate tenant protections, programs, and services. That's supported by a pretty succinct strategy of designing and distributing materials to inform the public of the tenant and landlord rights and responsibilities under local laws and regulations. Objective 2 is to increase engagement to better inform the community. And we have a few strategies there, including providing multiple methods for responding to questions and concerns from and providing information to community members, delivering presentations, workshops, and community meetings, engaging vulnerable and hard to reach community members, utilizing multiple modes of communication, including virtual and print media, and fostering relationships with community organizations. And then finally, the third objective is to foster transparency and trust in the community. And we do that through communicating updates and major changes to affected parties in the broader landlord-tenant community at large, and evaluating outreach and education program outcomes. These, the goal, the objectives, and the strategies are the same for fiscal year 2023-24 as they are for fiscal year 2024-25 for consistency's sake. And a comparative summary of the outreach and education activities performed in fiscal year 2023-24 with the prior fiscal year are there on the screen. We went ahead and gave you a quick overview of some of the information that is provided in our quarterly status reports and then compared them to each other. You can see here we have our public inquiries. The top categories for the 2 years were tenant petitions and property registrations, respectively. And then targeted mailings, how many went out, educational workshops, how many occurred there, housing help center and office hours, the number of total attendees, and the number of outreach events and people who were reached at those outreach events. And then wanted to provide you with an overview of the annual outreach activities. These are activities that we perform every year, and then provide you with some highlights for those. So the first one we wanted to focus on is that we responded to and provided one-on-one support for 3,440 inquiries from the public. And as seen in the other slide, a lot of those were tenant petition related inquiries, and that increase also correlated with the highest level of filings to date for petitions with the division during the prior fiscal year. And we also expanded attendance at outreach events to include events targeted toward vulnerable and hard-to-reach community members, including attending the Second Harvest Brown Bag for low-income seniors and Hope's Corner Breakfast distribution for individuals facing or at risk of homelessness. And we were able to reach quite a few people with that targeted outreach. We enhanced our outreach to families with school-aged children by attending additional school-based events at several campuses, and also went to events like Back to School Night, open houses, and Dia del Nino. We held the 3rd annual Summer Community Kickoff, which is a family-friendly, housing-focused resource fair that your division here puts on with our community partner organizations. And about 450 community members learned about housing and support resources available in the community. And as you can see, a lot of community members come out, and it's a very fun day that everyone participates in and just really enjoys. So we're very happy that we get to host those. We also strengthened our consistent digital communication by executing e-newsletters for the first time. You can see one here on your screen. Obviously, it doesn't only have our contact information, this just happened to be at the top of this one. Workshop information, registration updates, and program update emails. We implemented customer service feedback surveys, and I want to mention that the feedback received that you see on the screen, other than the tenant petitioner survey respondents here, is from all respondents, tenants and property owners, and whoever else filled out the survey. 97% of clients felt that they were helped in the office and agreed that they received the support that they needed when they were helped in the office. About 98% of all clients agreed that staff was helpful and courteous, and 97% of Help Center survey respondents felt that the information provided to them was helpful. And then we had some qualitative feedback that we wanted to share as well. You can see it here on the screen. I'm not going to read them, but I did want to mention that this does have represent both property owner, landlords, and tenant feedback. And then apart from the annual activities in the fiscal year, we also performed additional activities on top of what we typically do for our targeted and new programs, including obviously the very heavy lift of the RUBS and utility charges related outreach. So we developed and implemented an outreach campaign to educate all landlords and tenants of fully covered CSFRA properties of the regulations that significantly impacted utility charges and the required process to file the one-time utility adjustment petition. This included designing and distributing materials to inform the public of changes to utility billing through various mediums to meet the communication needs of a diverse audience, including mailing 2 utility update letters to property owners of 678 fully covered properties, mailing 2 postcards to landlords and 2 postcards to tenants to inform the community of key points of regulations and workshops regarding utilities, distributing a half-sheet handout with information about changes in utilities at in-person community events, integrating utility billing information and division communications to the public, sending 9 emails to the public related to utility billing updates, workshops, and resources, and translating key materials such as informational sheets, letters, and half-sheets, and handouts in Spanish and Chinese. We also facilitated 3 workshops for tenants and 3 workshops for landlords with major updates and information about the upcoming petition process, with 165 total attendees. We redesigned the rent stabilization website to help communicate important information more clearly and increase the ease of navigation, which is meets our objective 1 that you saw earlier. And you can see this on the screen. We have a landing page for both landlords and tenants, where if you click on these buttons, you can easily get to resources and information about those particular topics. And for the first time, we have a dedicated web pages to things like healthy and safe housing and the Housing Help Center for Landlords, compliance information. So it's really clear, obvious where you need to go to access information, and the information there is accurate and up to date. We expanded and updated our FAQs to accurately reflect the most current information for the public. This was a huge lift for staff. These FAQs are used frequently by staff to respond to inquiries from landlords and tenants. And we have these in print, and we also have this now on the website in a way that is easily accessible in this collapsible accordion format here, where if you go to the website and press on the plus sign here, it will actually show you the answers in a very easy to read format. And I do want to go back for 1 second, back to the information about the utility petition process, and mention that we've created a whole new resource hub webpage for utility related information that has a summary of regulations, information on the petition process, downloadable videos of workshops that we had to create, and other relevant resources, including informational sheets, materials, and all of the applicable forms that property owners need to complete the petition. We also have informational guides to help through that process. So all of that is new. And then we developed the supporting petition materials for the launch of the petition process in fiscal year 2024-25, which we're currently working in. And then we also conducted targeted outreach campaigns for the registration requirements and program updates related to that, including noticing and compliance requirements. And we saw a significant increase in fee payments, registration and compliance because of this increase in outreach and education, which resulted in the highest registration and fee payment compliance to date, as you see here on the screen. We had a pretty big jump from that 2022 cycle at 42% to the 2023 cycle at 88%. And now with these additional efforts that we've put in the last cycle, we had a compliance rate for registration at 94% and a fee payment compliance at 95%. And then finally, we launched the bi-monthly Housing Help Center for Landlords in October of 2023 in order to increase engagement with the landlord community and provide individual support with petitions, registration, and rent increases, among other topics. In the prior fiscal year, we were able to hold 17 clinics, and we helped 34 landlords. This fiscal year, we are holding these every week, and we've had quite a few participants. So as a reminder from what I mentioned earlier, the goal, objectives, and strategies outlined for last fiscal year will continue for consistency's sake into fiscal year 2024-25. And I'm going to review some of the highlights of what's been planned and already underway for this fiscal year. So we're starting with continuing to implement an outreach campaign to educate landlords of fully covered CSFRA properties of the utility billing regulations and the required process to file the one-time utility adjustment petition for landlords to comply with the law. We are collaborating with landlords to test the petition materials and process design. That is obviously underway. We are designing and distributing materials to inform landlords of the one-time utility adjustment petition through various mediums, including mailing newsletters, postcards, and handouts, integrating utility billing information in division communication to landlords, such as the rental housing fee invoicing packet and biannual newsletters. We're sending emails related to utility billing updates, workshops, and resources, and we're maintaining the translation of key materials in Spanish and Chinese. All of those are underway. We are also maintaining and updating the utilities webpage. and to serve as a resource hub, including the petition process and regulation updates. We're facilitating educational virtual landlord-focused workshops and tutorials on how to complete the petition forms and what to expect throughout the process. We are enhancing staff support for landlords by offering weekly, like I just mentioned, rather than bi-monthly housing help centers for landlords hosted by the division, which can be attended in person or virtually. And we're conducting targeted outreach to landlords based on submission due dates of the one-time utility adjustment petitions, such as direct contact through phone and email. All of these are underway already. And then here, number 2, we're developing and implementing an outreach campaign to inform the tenant community of the impact of the one-time utility adjustment petition. We're designing and distributing materials to inform tenants of the adjustment petition through various mediums, including mailings and e-newsletters. We're facilitating virtual tenant-focused workshops. We're working with community groups to share educational materials about what tenants can expect, and we're designing and developing concise educational materials that communicate key points for tenants. A lot of these are either started or upcoming, and we will be focusing a lot of our efforts on this for the remainder of the fiscal year. What you see on your screen here is a notice of filing that the division is sending out to all tenants after a landlord has successfully submitted their petition. And this is one of the supporting items that is going out from our division through this process. We're implementing an outreach campaign to inform landlords of registration and fee payment requirements and related compliance and enforcement mechanisms. This is something that we are focusing heavily on still. Obviously, this is an annual thing that we need to focus on and continue. We included the information in our annual invoicing insert, which is complete. Those invoices went out already. We're facilitating in-person and virtual registration and fee payment workshops, updating video tutorials and user guides, conducting targeted outreach to landlords on registration requirements, program updates, noticing requirements, and compliance requirements. We're mailing compliance letters for properties that are out of compliance with the CSFRA or MHRSO to landlords and eventually to tenants if the property stays out of compliance. And we are engaging vulnerable and hard to reach community members. You can see here a photo of some of our staff members with the members of the Multicultural Engagement Program from the City Manager's Office at the Chinese New Year event that the city hosts. For this particular goal, we will be distributing accessible materials in Spanish, Mandarin, and Russian within the community and at high-touch locations, including laundromats and grocery stores. We'll be connecting with the Chinese-speaking community via the Multicultural Engagement Program and known community members to perform targeted outreach to better inform the community about applicable laws. And we're developing realtor-specific trainings and materials. Those are underway. And then finally, we will continue to evaluate outreach and education program outcomes by comparatively analyzing quarterly activity reports, housing help center data, and customer satisfaction surveys. And then finally, the presentation that you received this evening has no fiscal impact on the budget. So that concludes staff's presentation, and happy to take any questions.
I have a quick.
Go for it.
Yes, thank you very much. One question I have, and I think this is something that we might have talked about at a previous meeting. My observation is that we continue to see landlord appeals to petitions that are really just way off base in their assumptions of the CSFRA, the RHC, constitutional law. I mean, and I actually don't mean that to make fun of anyone. You know, it isn't really, you know, I'm not trying to be negative about it, but to say that everyone values their time. Certainly the landlords and the petitioners, who are usually tenants, put in a lot of their own time, and no one wants to waste their time. No one wants to be disappointed. Everyone wants to be, you know, to have a fair hearing. And I really just, you know, it seems like so often we're just saying the same things, that basically this is how the law is, this is how the regulations are, this is how the RHC works. What I'm wondering about is what kind of assistance does staff provide through these workshops to try to counsel landlords in particular, because we see these issues recurring seemingly very often, to kind of guide them on what is a productive appeal and what is really not going to give them the response that they're clearly looking for. I'm just curious, how can we try to save everyone, including them, a lot of wasted effort?
That's a great question, and staff is happy to provide some insight into what we do on our side over here. One thing to keep in mind is that as city staff, we are not able to provide legal advice. We can only give insight into the process. One of the things that we focused on this past year, and that was also released during our current fiscal year, is we reevaluated the appeal request form to provide more information in the appeal request form itself about how to think about what you're appealing and what to consider when appealing it. We also have appeal information sheets that go out about the appeal process, what to put into your appeal request, and what will be considered by the RHC. So there is significant support that is provided while also trying to not, get into a situation where we're providing legal advice. We also do routinely, let people know that if they are seeking legal advice, then they should reach out to someone who can provide it in an appropriate manner. So we're cognizant of those things, and also of the due process issues, and making sure that everyone has the ability to achieve and access their due process rights under the law. We can't deny an appeal request, even if it doesn't meet the bounds of the CSFRA. We have to take it into account regardless of those things.
Yeah, no, and to be clear, I absolutely would never suggest either trying to abridge someone's legal rights or to give legal advice, because that is not the role. I guess is staff observing anything in these repeated appeal hearings where you feel like, hey, here's an opportunity where we could try to help these people out or make something go a little smoother? Because I'm just seeing this, it's like Groundhog Day. Every time we're going through the same stuff. Or is this just not tractable?
That is definitely something that we are aware of, which is why we have been working on at the very least making those forms as supportive as possible and providing support while people are completing that. It's definitely something that's on our mind, and we will continue to work on improving just the basic understanding of what the appeal process looks like. We're in the process of reworking the appeal information sheet and the petition process information sheet, just to give it a little bit more, to provide a little bit more information and guidance on both sides of, on the petition side and the appeal side, on what to expect and how to kind of work through the process. It is so legalistic that we have to kind of be very careful with the information that we do provide in that process. And so we work closely with legal counsel to ensure that it's information that we can be providing. I don't know if Naz or Karen have anything that they'd like to say.
I think the other thing is we might want to look at our appeal regulations and procedures a little bit, just to see if there's a way to eliminate some of the sort of consistent appeals, that not eliminate them, but to either expedite them or something, because we are seeing a lot of appeals now. And I do understand the issue that you're concerned about. But, as Patricia said, we need to give people the right to appeal. And in some sense, we can't judge the merits of their appeal in advance, but there may be things we can do through the process that we can look at.
Yeah, thank you. I totally agree with the delicate balance, slippery slope issues of getting into legal advice or prejudging. Yeah, so I appreciate the consideration. Just something to keep in mind, because I think it's on all of our minds. Yeah, thank you.
Robert?
Yeah, I'll just echo. I share committee member Balch's frustration with some of this, but let me just ask this question back to staff. It is the case that before the petitioner and the appellant come here, they do see the tentative appeal decision, right? And so they do have the opportunity to look it over and ask themselves the question, you know, I mean, do I agree with this or not? And if I agree with it, I can just not, I don't have to go forward, right?
Yes, although we don't have that explicitly in the regulations, and that's something that we could consider is a more drawn out appeal process in some way where the tentative appeal decision might be released and then the parties can elect it, whether they want to either accept that decision or actually come before the RHC and argue. I mean, sort of similar, I'm not completely, but you know, like when you appeal at the Court of Appeal, you can forego oral argument. So something like that we could consider, but it would make it a little more extensive because they only get the tentative appeal decision 10 days before your hearing.
Okay. Okay, so it's not, I mean, it sounds to me like you're saying that it's never happened yet that having read the tentative appeal decision, the appellant had decided that he's not going to go forward with it.
Not in my recollection.
Okay, okay.
No, we haven't had that. So, but, and to answer your question, the tentative goes out to both parties on the same day that you receive the tentative. So 10 days before the appeal hearing.
Okay, I bring that up just also because, we had the appellant, his first words out of his mouth in one of the hearings tonight, right, was that he thought he was going to lose. So, I mean, I just, if it would save time, I would be in favor of a regulation that allowed, one or the appellant to drop the issue if he had read the tenant appeal decision and had decided you were right.
I mean, I'm not sure this is directly on point with the agenda item, this discussion, but I do think it raises issues and we can consider a discussion at a future meeting on our appeal process.
Okay. So then the other thing I wanted to just say is, first of all, thanks for answering the questions that I sent in. And in particular, thanks for also providing a positive feedback comment from a landlord. And, but I just wanted to ask a question about the question 4 that I had sent in so that I understand it correctly. You put a chart there and it has the number of banked rent increases filed in the portal. Does that mean, so like for instance, on fiscal year 2019 to 2020, there's 117. That means that there were requests on 117 units to apply a banked increase?
That's correct.
Okay, okay. All right, so then I understand now what you're telling me, and then I'm going to wait till we have comments, and then I'll make some comments.
Edie.
So I'm just envisioning, I'm echoing some of the, discussion about, gee, what would deter appeals that are unlikely to win.
Some of the questions, right?
Yes, questions. And I'm just envisioning, a little before you appeal, FAQ. And one of the things I would put in that is, what? I need to go back 5 years to find the right base rent, and then I have to refund all my increases since that, the first time I made a mistake. That's ridiculous. And then some response to that, because I feel like that's one of the issues, or one of the items appealed, that, what do you mean I have to refund all that rent? And, I did my rent increases right. Yeah, except for, and then we have to go back to that date, and then they don't get to do rent increases since the mistake. So I just feel like, that's a message for us to promote educationally.
In the form of a question?
Perhaps before appeals.
Okay. Okay, so actually, in following on from Mark's, could we have examples of previous appeals that we feel were like well done, well founded, that we have video of that we could present to prospective appellants? Just think that here's one that went well, here's one that went poorly. Just to present, to educate them about what it could look like.
Staff can look at ways that we can give people more information about the appeal process and what a successful appeal would look like. We'd have to talk about how we would do that.
Yeah, without the advice being particularized. Yeah. Okay. Yeah. Any other questions for staff? Vice Chair?
Thank you. So back to the item, one of the items mentioned about outreach to families. I was wondering how effective do you think that those kind of, school-based activities have been for spreading awareness about the petitions and CSFRA processes?
They're actually highly effective. We have a lot of community members that come up to us directly at those events and have provided information actually on some very egregious living conditions and accessing their rights under the law, not knowing that they even had rights under the law to access. It seems to be actually one of the most successful outreach opportunities that we participate in.
Is this done in conjunction with both school districts or just one?
Both.
Okay. Thank you.
Yeah, and I do want to add that is part of the strategy of the city, Community for All, and to engage and educate and reach vulnerable populations in order to ensure their rights in housing.
Okay, thank you.
Edie?
So when do you anticipate that we'll get some report back about the utility adjustment petitions?
I can provide information about that this evening during the last agenda item.
Great.
All right, if there are no further questions, we can do some public comment. Any member of the public wishing to provide virtual comment on this item, please click the raise hand button in Zoom or press *9 on your phone. Staff will display a countdown timer on the screen. Seeing no comments, we will go into committee deliberation and feedback. Any comments for staff? Robert?
Yes. So yeah, I just wanted to talk about a couple things. First of all, question 4. Let me tell you why I'm asking this question about, bankable increases. And that's just that, I look at this and I love numbers, I guess. So I looked at the 9-year span that we've had since, did I get that right? The span since we started the CSFRA, and I looked at what the increase was in the rents on the rent-controlled units for new vacancies coming up over time, and it was 2% on average. And but you've pointed out that the AGA has been on an average of about 3.5%. And so what my concern is, what I'm wondering about, could it happen that if there's a divergence between how much the landlords are allowed to raise the rent and how much the rents are actually going up for new tenants coming in, that the amount that landlords are banking could be increasing, and that we might get a shock at some point, okay, of people applying bankable increases all at once, and what the effect would be. So let me just ask the question back then again. I think there's a limit on how much you can bank. Isn't that right? Like 10% or something like this per year?
There's a limit on how much you can give in a rent increase each year, no matter how many rent increases you have banked.
Okay, so then you can't increase the rent more than 10% based on banking, right? In a given year, right?
In total. So inclusive of the AGA plus the banked increases, it cannot go above 10%.
Okay. So then, at least there's some ceiling on it. And as far as, the difference between 2% and 3.5%, it may just be small enough that it isn't, it isn't really largely noticeable at this point. And, looking at the statistics that you sent out, I see that, if it had been a real problem, I would have thought in the last 3 years, the numbers would have been consistently going up, and they're not. So thanks for the information. I'm less worried now, but I like to keep my pulse on things. So then another comment is just that I'm glad to see again that the vacancy rates for the newly built units is going down again. So it was at 15% the last time, and now it's at 8.5%, so that's a positive thing. I'm glad to see that the vacancy rates for the fully covered units are at about 5%, which is just about the ideal. I did notice it's slightly less for the 3-bedroom units, and that just comes because I think in general we're challenged in this, in the time that I've been involved in discussing these kinds of things, of getting, what you call family units. I mean, most of them are older, and, there's more demand for them than in other units. But in general, I think that's a good trend. The fact that there were no Treo units in 2024 and only one in 2025 shows that even though we spent extensive time talking about it, and it's important to get it right, it's not having a major effect on people right now. And that's... do I have anything else? Yeah, just one other comment. A constituent had approached me and had said that that constituent felt that that RHC staff was trying to dig into the landlords by extensive outreach into the community, which had a negative effect on raising the issues to landlords, and then having these hearings come up where more and more petitions get filed, and it's kind of it's a feedback loop, okay, was the comment that was made. And, asked me what I thought about that, and so I want to make a comment to the public here on my thinking about that. Honestly, I think the staff's doing the right thing. And I think that we have a community which is relatively new to rent control. I mean, it hasn't been even a decade out yet. And, the real thing about it is that most people don't come into the situation of when they move here into this community of knowing what their rights are and knowing, what they can do about things. I mean, I can even speak to my own past experience and say that, I had a landlord who, in my opinion, seized my security deposit without justification, and yet I had no idea what I could do about it. But if, there was a mediation program in the city at that point, had I known about it, I would have availed myself of that. I mean, and even in what I listened to tonight in terms of quiet enjoyment of unit, I mean, when I lived in Texas, I don't know what the laws were in Texas, but I mean, I had two different situations that I came across. One was a guy who lived 2 floors below me who just wanted to play his stereo as loud as it possibly could go. And I didn't know whether I could do anything about that. And another case where a guy in an adjacent unit, it was rented out by a band that liked to come home after the bars closed and practice from 2 to 4 o'clock in the morning. Okay, and I think that if this had happened I've never had that problem in Mountain View, but if it happened in Mountain View, I would think it's great that we have staff to let people know what it is, their rights are and what it is, they can do about something. So I feel at this point, we're kind of at the point where the community isn't even yet at a steady state of knowing widely what what their rights are. And I think, if people asked me if we got to the point, when would that be? And I would say this, that if you were renting an apartment and you had a good friend there, and that friend had lived in the apartment maybe a couple more years than you had, and if you would be able to go over to your friend and ask him about a problem that you have, and they would know what the answer is without having to go to RHC staff, then I think the community's at the point where they have knowledge, general knowledge, and maybe RHC staff doesn't have to do as much, but I don't think we're at that point. And there's a flip side to that whole question I was asked, and that was the one that, are we at a point yet where landlords don't sit on problems to see whether or not, they'll be challenged, and just always do the right thing, and so that we don't have to have these hearings. And I don't think we're probably most landlords are okay in this city, but there's enough of them that haven't quite come to that realization yet that I think we're still in a point where we need to continue, an intensive initiation of what we're doing here. So that's my comment about that. And I've said enough. Thank you.
Thank you. Vice Chair?
Thank you, Chair. I have 1.5 questions and a comment. The 1.5 question is, remind me, have we made any articles onto the City Hall Connections newsletter? And if so, what was the last time we did something on it?
The council connection?
No, that's the half question, but the City Hall Connections, there's the public one, and then there's the one for council. The public one, I think, is once per month.
We haven't had any on the City Hall connection, I think, in a while.
Okay, I was wondering maybe since we might get to Rubs later today, maybe an item for Rubs on there. But also for the half question, what was the last thing we put for the council connections newsletter?
I think that was last June or around that time period with the last quarterly status update for the fiscal year. It's been a little while there too. We have to coordinate with the city manager's office for that.
Yeah, it's always good to keep council aware of the actions we're doing here, just because we are an independent body that has...
Especially with 2 new council members to keep informed.
Fair. And the general comment is, I thank staff for all their efforts on outreach. This is probably the most amount of outreach any department does in the city, or probably cities in plural in our neighboring jurisdictions. And I think that's great for members of our community to utilize their full legal rights.
Anki?
Sorry.
Oh. You're done? Oh, okay. My turn. Yeah. No, I think our staff does a great job, and I appreciate not just the volume of information, but the structure of it. I think that it's really well done and useful for people. I know that when I'm asked questions, I'm able to find answers to send to people quickly, and that's all I want. So, good job. Thank you. All right. If there's no more discussion, we can now hear about item 6.2, the annual update on relevant legislation and case law in California. Public comment will occur after the presentation item and committee questions. We invite you to submit a speaker card now if you know you would like to speak on this item during public comment. We will begin with a presentation from staff.
Thank you. So the purpose of this item is to provide the RHC with updates on legislation adopted by the California legislature during the 2024 legislative year related to landlord-tenant laws, as well as recent court cases related to just cause for eviction and termination notice requirements. So perhaps the most significant change, even though a very short bill, is AB 2347. This bill extends the time for tenants to file an answer or any other type of response in an unlawful detainer case to 10 days. Previously, it was 5 days, excluding Saturdays, Sundays, and judicial holidays. And those 10 days, as a reminder, are counted from the date on which the tenant receives the summons and complaint for the unlawful detainer action or the eviction action. AB 2801 is related to security deposit documentation requirements. So this bill requires landlords to take photos of the rental unit within a reasonable time after the tenant vacates, but before they undertake any repairs or maintenance, and within a reasonable time after the repairs or cleanings are completed. So almost like a before and after of the repairs or cleanings that the landlord does that they will that they will be seeking reimbursement from the tenant security deposit. It also requires the landlord to send copies of these photos along with the itemized statement if they deduct for the repairs or cleanings from the tenant's security deposit. And these photos can be provided by mail, email, flash drive, or a link to a Dropbox, Google Drive, whatever it is that the tenant can access. And these provisions become effective on April 1 of 2025. So additional requirements effective for tenancies that commence on or after July 1 of 2025, landlords must take photos of the unit immediately before or at the beginning of a new tenancy in order to basically document what the condition of the unit was at the time that the tenant moved in. This bill also limits the claims that a landlord can make against a tenant security deposit or against a tenant for materials, supplies, or work to a reasonable amount necessary to restore the premises back to the condition it was in at the inception of the tenancy, exclusive of ordinary wear and tear. And so the purpose of this, as stated in the bill itself, is basically to prevent landlords from upgrading the unit and charging that against the tenant's security deposit. So putting in something, a refrigerator or, other appliances, carpet, flooring, whatever it is that are way nicer and more expensive than what the tenant received at the beginning of their tenancy, and then charging that to the tenant's security deposit. Similarly, for the same reason, landlords cannot make claims for professional carpet cleaning or other professional cleaning services unless those are necessary to restore the premises to the initial condition in which the tenant received the unit. AB 2747 relates to credit reporting. So this bill requires most landlords in the state to offer tenants the option of having their positive rental payment information reported to a nationwide consumer reporting agency. Positive rental payment information means all complete, timely payments of rent by the tenant. It establishes the timing, the form, and the contents of the offer. So there's actually a list of requirements of what the offer that the landlord makes to the tenant of having their positive rental payment information reported must include. And it provides that for leases that are entered on or after February 1st of 2025, the offer must be made to the tenant at the time that the lease is entered and then at least once annually thereafter. And then for leases that were in existence as of January 1, 2025, then no later than April 1, 2025, and annually thereafter, the landlord must make that offer. It's not really clear what happens to the leases that come into existence between January 1 and April 1, but I assume that they would have to also make that offer by April 1 of 2025. And then the landlord can charge the tenant a fee for the cost of the reporting. It either has to be the lesser of $10 a month or the actual cost to the landlord of reporting. And if it doesn't cost the landlord anything to do the reporting, then they cannot charge the tenant any fee for having their payment information reported. So this bill also allows a tenant to request that a landlord stop reporting at any time. However, if the tenant does make such a request, then they can't request that the landlord start reporting again for at least 6 months. And then the requirement to offer the reporting doesn't apply to a landlord of a building with 15 or fewer units unless the landlord owns more than one residential building and is a real estate investment trust, corporation, or a limited liability company in which at least one member is a corporation. It also doesn't apply to assisted housing developments, which are typically, you know, units that are subsidized by some sort of government program. AB 2493 provides that a landlord may not charge application screening fees to tenants unless they offer one of the following: either an application screening process that has all of the following features. One, that the completed applications are considered in the order they are received, that the first applicant who meets all of the landlord's criteria is approved for tenancy, and that applicants are not actually charged the fee unless and until their application is actually considered, or an application screening process in which the landlord returns the entire screening fee to any applicant who is not selected within 7 days of selecting a different applicant for tenancy, or within 30 days of the tenant's submittal of the application. SB 611 limits the types of fees that landlords may charge tenants. So specifically, landlords can no longer charge a tenant a fee for serving, posting, or delivering any notice of termination of tenancy required by the Civil Code. They also cannot charge the tenant a fee for serving, posting, or delivering any notice of termination of tenancy, notice to cure or quit, notice to pay rent or quit, notice to quit, or other notice required by the Code of Civil Procedure. So these are all just going to be your typical like 3-day or 30 or 60-day notices. And so landlords can't charge for the cost of having those served or mailed or delivered to the tenant. And then the last one is an important one, but landlords may no longer charge an extra fee for a tenant's payment of rent or a security deposit by check. So no additional fee can be required if a tenant chooses to pay by check. AB 2579, so this builds on a bill from 2021 SB 607 that required local code enforcement to inspect all balconies and decks in all multifamily buildings of 3 or more units by a specific deadline. That deadline for the initial inspections was January 1st of 2025, so it extends that deadline and gives local code enforcement more time to complete those initial inspections. They have until January 1 of 2026. And then they also have to inspect every 6 years thereafter. SB 1051 relates to protections for survivors of domestic abuse. So it expands state law protections to these state law protections to all eligible tenants. And eligible tenants means a tenant who is a victim of abuse or violence, or a tenant whose immediate family or household member is a victim of abuse or violence. Previously, this applied only to protected tenants, and those were tenants who had a court order or a police report demonstrating that they were a victim of abuse or violence, or that their immediate or their household member was a victim of abuse or violence. And so the requirement for a police report or a court order has been removed, and also now if you have any immediate family members who are a victim of abuse or violence, then that will also qualify you for these protections. So what are the protections? It requires the landlord to change the locks of an eligible tenant's unit within 24 hours of the tenant's written request. The written request must include documentation of abuse or violence. And the type of documentation, as I mentioned before previously, was just a police report or a court order. This allows for many more types of documentation, including documentation from a third-party professional, such as a counselor or therapist, that certifies that the individual is a victim of abuse or violence. So it provides that a tenant may change locks without the landlord's permission if the landlord doesn't change them as required within 24 hours, and that the tenant can seek reimbursement from the landlord for the cost of replacing those locks. There are some requirements around what the tenant must do if they choose to change the locks themselves. They must change the locks in a workmanlike manner. The locks must be of similar or better quality than the locks that are being replaced. They must notify their landlord of the change within 24 hours, and they must provide their landlord with a copy of the key to the new locks. And then the last change that this makes is that it prohibits any adverse action by a landlord against a prospective tenant based on the fact that they've had their locks changed because they were an eligible tenant, or solely on the basis that they are a victim of abuse or violence. And adverse action means denial of a rental application or approval of a rental application with less favorable terms than those in the listing or ad, such as a higher security deposit or a higher rent or something like that. AB 846, this relates to limitations on rent increases for proper tax credit properties in California. So in this past April, the California Tax Credit Allocation Committee adopted regulations limiting rent increases for tax credit properties that received their tax credit allocation after April 3rd of 2024. This bill expands the limitation on rent increases to all tax credit properties in the state, regardless of when they received their tax credit allocation. And so the CTCAC is required to adopt regulations by June 30th of 2025, setting the annual rent increase limit for those properties that receive tax credits before April 3rd, 2024, and are subject to a regulatory agreement. So more information to come on what that limit will be for those properties, but this helps to fill in, one area where the CSFRA doesn't cover rent increases. Okay, getting into a couple of significant cases. The first is San Francisco Apartment Association versus City and County of San Francisco. So this case relates to an amendment to San Francisco's rent ordinance that was made in 2022. And the changes that were made were to require the landlord to provide a tenant with a cure notice for any outfault just cause. So that's going to be like your non-payment of rent, nuisance, illegal activity, breach of the lease. So this required the landlord to provide a tenant with a cure notice, or what is called a written notice to cease in some places, for any at-fault just cause. And then also required the landlord to provide at least 10 days for the tenant to correct the violation. So the property owners sued seeking an injunction, and the basis for their case was that these provisions of San Francisco's rent ordinance were preempted by state law unlawful detainer statutes, which established the time frame for noticing of any terminations of tenancy, notices to pay rent or quit, etc. So the court held that under the framework that was established by Birkenfeld v. City of Berkeley, the city of San Francisco could require a written notice to cease or a cure notice for these at-fault just causes. However, they could not extend the required notice period for the at-fault just causes, meaning that they could not require at least 10 days notice to correct the violation. And so basically the first requirement the court determined of requiring a written notice to cease or cure notice was a substantive requirement, whereas the second was a procedural requirement, and it did conflict with state laws that establish the noticing periods for terminations of tenancies. And this is relevant here to you all because the CSFRA does provide for written notices to cease in certain circumstances. You know, you're okay because yours does not establish any like specific time period to correct the violation. So, you know, doesn't run afoul of basically what this case determined.
I heard something. Now I don't hear anything.
Okay, sorry. I don't know why it keeps doing that. I need to figure out what the setting is that makes it do that. Okay, second case is City of Alameda versus Sheehan. In this case, the tenant received a 3-day notice to pay rent or quit. And Code of Civil Procedure Section 1161 2 requires that any valid notice to pay rent or quit include the name, telephone number, and address of the person to whom rent shall be made. So the tenant in the unlawful detainer action argued that the 3-day notice was defective because it named a corporation rather than a natural person to whom rent must be paid. The court rejected the tenant's argument, though creative, and said that the notice may name a corporation or other business entity, not just natural person, because the meaning of the term person within Code of Civil Procedure Section 1161 included, you know, a corporation or other type of business entity that might own a property or collect rent for a property. And the last one is Campbell v. FBI Management. This relates to noticing periods for federally subsidized housing. So the property management terminated tenancies in federally subsidized housing where tenants defaulted on rent with less than 30 days notice. They provided only 10 days notice where the tenants had failed to pay rent. 2 classes of tenants in federally subsidized housing sued the property management for unfair business practice on the basis that they had not provided the correct amount of notice to them, and so therefore they should receive restitution and be able to go back to their units. The 2 classes of tenants were tenants in units subsidized by the Home Investment Partnership Program funds, and then tenants in units subsidized with Section 8 funds. All you need to know there is those are 2 different sources of funding under in the federal government that provide for affordable housing. The court held that the home tenants had standing to bring this case related to the unfair business practice because the home program required 30 days notice to terminate tenancies of tenants who were in those units. On the other hand, the Section 8 tenants did not have standing because there was no statute or regulation or rule that required 30 days notice where the tenants had defaulted on the rent. So just a kind of interesting case about how tenants in the same building could have slightly different rights. And I think that's the end of this presentation. I'm happy to take questions on any of these.
All right. So first things first, question from committee members. Edie?
So where there was legislation, I believe, to limit rent increases in tax credit properties, limit to how much?
Yeah, so that's what the CTCAC, the California Tax Credit Allocation Committee, has to establish by regulation by April 1 of this year. So, or sorry, maybe June 30th of this year. So unclear yet. I don't know, Karen, if you have more insight into what they might be thinking about. You work more with tax credit stuff.
I mean, they had adopted regulations applicable to some tax credit units that limited rent increases to the same limitation in the Tenant Protection Act, which is 5% plus the CPI, but no more than 10%. So my guess is that's going to be the range that they're going to land in.
All right, Robert.
Yeah, thank you for this update. It was just really illuminating. The one thing that I'm still trying to get my head around is, this idea that when it comes to positive credit reporting, they say that it cannot exceed more than $10 a month. And then I'm thinking okay, so let's say I'm a tenant who wanted this positive reporting and I wanted reporting for a year period. I mean, could it really potentially cost me $120 to get such a report issued to somebody that I cared about? And, I know it can't be more than the actual cost, but I'm just wondering whether you have any insight, could it be that am I thinking right about how much it potentially could cost? And is it that these credit reporting agencies could be dinging the landlord for large amounts of money and that's why it could be a large cost? I don't know. Any thoughts on that?
Yeah, I mean, it could potentially be $120 a year. That is what the maximum would be. I think it's going to depend on staff time. That might be what landlords. I don't know what the process is of reporting and how much work it really takes on the part of a landlord or a property management company to do that. But, as far, just comparing it to other things, for instance, like late rent payment fees, those are supposed to be tied to the actual costs of staff time, the expenses that the landlord incurs as a result of the tenant paying their fees late, or paying their rent late. I'm sorry. So I assume that a similar standard would be applied here. One thing that this statute does do, which I think is a positive, is that it says that if the tenant doesn't pay whatever the cost is of the reporting, that can't be the basis for an eviction. That can't be the basis for negative reporting. Basically, what happens is that if the fee remains unpaid for 30 days, the landlord can stop reporting. And so, luckily that is not something that a tenant can turn into a catastrophic situation for a tenant. If they stop paying it, they would just stop receiving the service. But yeah, it is, good amount.
Okay, thanks.
Mm-hmm.
Edie?
So this is a question to our CSFRA staff. Is it possible, or are there any plans to, some of these are great pieces of legislation. Can any of your updates include things like before you lose your security deposit, your landlord needs to take pictures and provide you those pictures?
Absolutely, yep.
Definitely. We have workshops on things like, gosh, I can't remember. I think it's just in our basic rights and responsibilities workshop. We have another one that has specific information about what tenants and landlords should do at the start of tenancies and at the end of tenancies. And we'll definitely update those workshops to reflect this new legislation.
That sounds great. And the other thing that I would look for is just whatever you can squeeze into any of the updates you send that go to all tenants. We have newsletters to all tenants? Okay, yeah.
Sure.
That's exactly what I was just thinking. Great suggestion.
Thank you, Chair. This is a question for legal counsel. This is just a pure personal interest question. So back on AB 846, the CTCAC item. So this is basically requiring them to revise all regulatory agreements made previously. Isn't that just kind of requiring them to renegotiate all their contracts, or is there some kind of public policy thing they could cite
This is the tax credit rent increase?
Yes.
Um,
I'm saying this in
it's-
more an analogy for like how we do the BMR program, where the BMR is done as a contractual basis between the city and an individual owner, not city CAC in this context, but like when can those kind of agreements be modified?
Well, they can be modified when the state legislature says,
Okay, so
this is the limitation on rent increases. That's effectively what's happening. So the California Tax Credit Allocation Committee has authority to change their regulations anytime they want and apply them to existing tax credit units for any unit that they have a regulatory agreement on. So it's not really modifying the regulatory agreement, it's modifying the rules under which the units operate.
Okay, so it's the contract clause wouldn't kick into effect because that kind of language was never in that. Okay, compared to the one we have for BMI properties. Okay.
Right.
All right, any more questions? All right, we'll now ask for public comment. If you'd like to make a comment on this item, please raise your hand or press star 9 on your phone. All right, seeing no comments, on to deliberation. Robert?
Yeah, I just want to make a few comments. Thank you very much for this update. That's very, very useful for us to know how things are changing. And I just wanted to say that in particular, this has helped move in a positive direction my feeling about what our state legislature does. I'm well known as a person who hasn't been real happy with a lot of the land use decisions lately. And yet, as I look over the balance of this, I feel like this really shows effective government. And in particular, I'd like to call out the things like the restrictions on the tenant screen fees and other fees. It seems like this is a good way of addressing, fees that are just made up as an opportunity for getting more money by just attaching it to some process that the tenant has to go through, and that's just fundamentally wrong, and I'm glad to see the correction for that. I'm also, very happy to see, the legislation on balcony inspections, because the previous place where I lived, which is a townhome complex, we had no end of problems with balconies rotting out and this kind of thing, and I've heard that it's also true in other complexes, almost to the point that, balconies are a dangerous thing to put into place in terms of like how they degrade and how they lead to unexpected costs for remedy with homeowner associations. So attacking a real serious problem, and waterproofing is a key issue with those. So I'm glad to see that too. And also the third one is lock changing for survivors of domestic violence. That's just a fundamental human justice issue. And I'm glad to see the legislature taking it by the horns and dealing with it in a very effective manner. So those are my comments.
Thank you. Any other comments? Deliberation? Feedback? All right. So we can now move on to committee staff announcements and updates. So back to staff for more presentations.
Thank you. All right, so I will be presenting on agenda item 7.1, upcoming workshops and help center dates. And I don't have to go too much into detail because Patricia covered a lot of this. So as we know, we do continue to have our once a week virtual office hours every single Tuesday from 10 a.m. to 12 p.m. And we have seen a lot of people utilizing those office hours. Also, we can see here our upcoming workshop dates. So we do have a property owner registration and annual fee workshop. We're trying to get as many people in before the deadline of January 31st. So our landlords, our property managers can join us virtually on January 28th at 2 p.m. And then we're having some understanding utility adjustment petitions workshops. So we have a tenant virtual workshop January 30th at 6:30. And then we have a landlord-focused virtual workshop for submitting the utility adjustment petition on February 6th at 2 p.m. And we are continuing to have our landlord housing help center every Thursday. So we're still doing this every Thursday for the time being, especially during property registration, fee payment, and utility adjustment petition time. So we don't have a plan at the moment to go back to our first and third Thursday schedule. We'll continue to do this every Thursday for the foreseeable future. And that's both in person and virtual. Our tenant housing help center is still the first and third Thursdays of the month from 6 to 8 p.m. at our office at 298 Escuela or online. Thank you. Any questions?
Edie?
And go ahead.
I think Edie's probably going to ask you for the thing you're about to say, maybe.
Right. My microphone fell. How is it going? What update can you give us about utility petitions coming in? And have there been any opportunities and any contested ones by tenants?
We have had a total of 33 properties submit petitions for review for a combined total of 3,684 units. That is not how many we have talked to or in the process of working on petitions with. That is a higher number. We have had some that have received tenant responses, and we are working with the tenants and then now the property owners to address the concerns and the responses. Happy to answer any other questions that I can.
I mean, do you feel that because the largest landlords are going first, correct?
Correct.
And are there any that you think will just not do this, or is everyone in touch?
Hopefully we will prevent that from happening. We are going to start a very extensive push campaign in the month of February. We were really working with the competing deadlines of registration and compliance with that, and then this petition process as well, and not wanting to confuse and flood people with information with contradictory deadlines. So we've been very conscious about what we've been putting out, and while also putting out quite a lot of information, including information in the invoice inserts for the rental housing fee that included information about the utility petitions. We are going to start with emails and phone calls to the properties that have, not provided or provided us with any indication that they are filing the petition with us. We do anticipate that we will receive a flood of them toward the end of February, which we're actually trying to kind of prevent. We'd like to see them earlier than that. But like I said, we will start with emails and phone calls. We've already done an email campaign. We're going to do another few email campaigns coming up here as the deadline gets closer, because it is such a significant issue if they don't file them. We'll also do some direct mailings to property owners of these larger properties to hopefully get them to file the petitions in time. So multiple touch points in multiple ways of communication.
Thank you.
Any other questions from the committee regarding utility petitions?
Nope. I look forward to the update as things come in. Hopefully the landlords are paying attention and listening to the outreach. All right, so this is now my turn. So future agenda item for Thursday, February 27th, 2025, my lovely wife's birthday. We're going to talk about the annual registration rental housing fee update and tenant anti-harassment or retaliation protections. Are there any additional comments or announcements?
And you will have 2 appeals.
And 2 more appeals.
Yes, 2.
Yeah.
No, I do not.
Yay.
Just trying to 1 hour per language.
Mm-hmm. Yep. We'll make it work. All right. Any additional comments or announcements from committee members or city staff? Then it is time to adjourn the meeting at 10:42 p.m. Next rental housing committee meeting is scheduled to be held on Thursday, February 27th at 7 p.m. Good night, everybody.